Hey, 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 all persons having anything to do before the Honorable, the Justice of the Appeals Court, now sitting in Boston Law and within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts, this court is now open. Please be seated. Good morning,
Good morning and welcome to the Appeals Court. My name is Peter Sachs. To my right and your left is Justice John Englander. To my left, your right is Justice Marguerite Grant. Will be your panel for all 6 cases this morning. If you've been here before, you know we have 15 minutes per side. There's no rebuttal. When the yellow light goes on, you'll have 90 seconds left. When the red light goes on, you can finish your sentence, and we may have 1 or 2 more questions for you, possibly. We've read your briefs. We've read the record. We know the arguments. We know the procedural background and the facts. We would urge you to get right to the heart of the arguments that you want to present to us today, because 15 minutes goes very quickly. And also, if you see us looking at our iPads, we're not looking at Facebook or checking the debate commentary. We're looking at the record or your briefs or looking up a case. We're still paying attention to you. So with that, I will call the first case, which is 24P45, Commonwealth versus Cadet.
Good morning. May it please the Court. Catherine Jansen on behalf of the Commonwealth. The Commonwealth would respectfully request that the Court reverse the allowance of the defendant's motion to dismiss for annoying accosting a person. I would like to start first with noting the standard that we're at, which is probable cause, and we're looking at what is in the application for complaint in the light most favorable to the Commonwealth, which I think is important when we're looking at the facts in the police reports that were appended to the complaint. And based on that standard and in the light most favorable to the Commonwealth, the facts were sufficient to establish that the defendant's conduct and language were both disorderly and offensive. I would first just go back to the context and lay out the facts very briefly, because they're very important. They inform both prongs.
I think we've probably got the facts. If not, we'll maybe ask you. I would like to ask, what is the imminent physical harm that a reasonable person would have feared based on the defendant's conduct here?
Of course. I think the imminent physical harm would be where he took his hand and made that comment, "I'll take your time with you," in the victim's view in reference to her age, after he had followed her and asked her out on multiple dates, which I would suggest are more romantic than platonic. Their imminent physical harm could be unwanted sexual contact or unwanted sexual acts that he would possibly try to do on her. And I think that was reasonable based on...
What is the evidence that that was imminent? Even assuming that I accept your, your suggestion that there's something physical to it. What's the imminence?
I think the imminence is the fact that he hadn't taken no for an answer yet, and he was asking for her phone number. And so I think she wasn't sure at that point, or I think the evidence would be reasonably to infer at that point, she doesn't know what he's going to do, if he's going to try to do something then, if she continues to rebuff his actions. She only gave
him no for an answer? I mean,
I'm sorry?
Did she actually give him no?
She did.
In the answer. I know that's a figure of speech, but...
Right. In the police report, she said she immediately told him to leave her alone. That's either at Record Appendix page 11 or page 13. Yeah, and she requests, so she, on Record Appendix page 11, he approached her and he identified himself, and she immediately informed the male after he had asked her for a date that she was only 15 and requested that he leave her alone. And then he continued to badger her for her phone number. So I think again, we're looking at this light most favorable to the Commonwealth, and obviously it's not as fleshed out as it's going to be at trial. And the problem is with a lot of the cases is we're looking at testimony that's been elicited at trial and proof beyond a reasonable doubt standard. We're looking at what evidence usually is enough for this charge. So I think at that point, and after that, and when you read the 2 police reports together, she talks about how she gives her phone number after that because she was afraid of what he was going to do if she didn't give the phone number. So I think on those facts, it's reasonable to infer, at least for probable cause, that there could have been an imminent fear of physical harm. And I think this was physically offensive conduct because unlike Ramirez, where there was no physical touching, there wasn't enough for an inference, at least beyond a reasonable doubt, that he had followed her. Here, I think there's a reasonable not only was there touching, and I think he touched her without cause, I think a reasonable person could find that.
Didn't he shake her hand?
She said he shook her hand, but however, that there was no reason to shake her hand in that moment, and I think
Well, but that's the only physical contact, is a handshake, right?
that's the only physical contact. However, physical contact's not even necessary. I think there's also the inference that
But
he
you
followed
keep
her.
emphasizing the physical contact.
I think it's very important and pertinent
And
here.
what we're talking about is a handshake. So I have a lot of difficulty with that because handshake is the way that,
I don't think
Well-
I think you need to look at the context of this. This is a 15-year-old girl who was followed home after she was working, after she had seen this older male staring at her place of work. He followed her after, and I think there's a fair inference from the evidence that he followed her and waited to
what's the
approach
fair
her.
inference that he followed her?
Because
Where
he had
is
seen,
that?
the fair inference is that he'd seen her at Market Basket. She saw he was staring at her. If he wanted to talk to her, he could have talked to her then, and he didn't. But instead,
Where did it say he wanted to talk to her? All I remember, I mean, we have to talk about exactly what's within the four corners, okay?
And the fair
And then we
inferences.
can talk about reasonable inferences, but what's within the four corners is he saw her, she saw him staring at her.
And then she was walking home an hour later.
But
and-
what you said a few moments ago, that he tried to talk to her.
I said-
There's
no,
no
I-
evidence in the police report that he tried to talk to her at Market Basket, is there?
I said if he had wanted to talk to her. I didn't say he did try to talk to her at Market Basket.
Okay.
So I'm sorry if the court misunderstood what I said. My point was that when I'm talking about the fair inference that he followed her, he was staring at her, he had noticed her. And I'm suggesting that if he had wanted to talk to her when she was around people, he could, when she was around people and her coworkers, he could have. But then an hour later, she's walking home while she's by herself, and then he calls out to her from behind, I would suggest, because she turns around and sees him, and he says, "Hey, Market Basket girl." So I think there's an inference there that he had been watching her and he followed her. Again, this is probable cause.
Except that he goes into the dollar store right afterwards, right?
After he got her phone number and got what he wanted, after he had touched her, and I think, quite frankly, you could find intimidated her into giving it to her. She's a 15-year-old girl, and he did that regardless of knowing her age, and he kept asking her out on dates.
So as far as the following, the police report says that the Market Basket is at 2 Water Street and the dollar store is at 200 Main Street. From this record, we don't know how far apart those are or how you get from one to the other. She inferred that he must have followed her previously to know that that was her usual walk home and positioned himself at the dollar store to wait for her. Is that a reasonable inference?
You know, I don't know if it is, because there's nothing in the record to suggest he had seen her before that. And I don't think that her inference based on, in that second police report, I believe, that he maybe had watched her before and followed her home. I don't think that's necessary to make this here, where I think you have the other reasonable inference that he had seen her and he was hanging around waiting for her and then followed her to that spot. I didn't argue about where those were geographically because I didn't think it was in the record.
She told the detective, the victim stated the only reason the defendant knew that was the route she took was if he had watched her before. So in the light most favorable to the Commonwealth, do we need to assume that he had watched her before?
I mean, I think you could, because based on her statements, if it's not super close, apparently, to the Market Basket, again, it's not on the record about exactly where it is. So if that's the case, then I think you could assume that's a reasonable inference in light most favorable to the Commonwealth that he would have to know where she was going. But again, I don't think it's necessary for you to come to the conclusion that there was probable cause in the complaint for the reason I had already stated.
So we talked about physically offensive. What about the threatening branch of?
Sure. So it can be, for disorderly, it can be either physically offensive or threatening. I argue both. And for threatening, I think, and I want to say, I did not mean to mischaracterize Sullivan in my brief on page 20. My sister pointed out that I accidentally had said that Sullivan stated there doesn't need to be an explicit threat or intent to harm. I meant to type explicit threat of intention to harm. I just wanted to clarify that. But here, I think the threat, I think it's implicit. I don't think there was an explicit statement, I'm going to do X, Y, and Z to you, but I think it's implicit that he was possibly going to do some unwanted sexual act to her, and that would be threatening to a 15-year-old girl, based kind of on our discussion about why this is offensive. He had, I think you could find from the police report that he had followed her. He had waited until she was alone to approach her. She was isolated, not with her
Do
coworkers.
we know that?
I'm
That
sorry?
she was alone and isolated? I mean, this was outside the market basket, or, sorry, outside the dollar store where she is when he approaches her?
Well, I think it's fair to say that she's not with her coworkers. I think she would have stated she was with somebody, and she felt uncomfortable, and I think there's a fair inference that she's by herself.
Does she say she's by herself?
She doesn't
I mean,
explicitly.
I'm not saying she knew anybody necessarily, but for all we know, this is a crowded street.
It's 3 o'clock in the afternoon on a main street, right?
I mean, I don't know if it's a main street. I would assume,
Well, that's
based
the
on a
name of the
retail
street.
store.
It's the name of the street, and that's all I meant. And so it's 3 o'clock in the afternoon, it's on Main Street, they're outside a dollar store. He walks into the dollar store afterwards. Again, reasonable inference that she's alone and isolated?
I think it's reasonable inference that she's alone by herself, meaning not with her, near her coworkers or other people she knows. I mean, I don't think somebody who sees a person talking to a teenager is going to come up and intervene. I mean, she could feel that he referenced having a car. She doesn't know if he has a car right there, and he's already touched her, that he could try to take her there. I mean, you have to look at the entire context of everything. I think it's fair inference that she's by herself and that she's not walking in a group.
How do you distinguish this case from, I mean, I think the answer is probably too obvious, but is it Ramirez is the case?
Ramirez with the swimming pool and the I Fell in Love with a Young Girl song.
Yeah.
Yeah, I think this case is definitely distinguishable from Ramirez. One, there was no physical touching, which I think is probably maybe the obvious difference that you were alluding to.
Proximity. I have trouble with calling a handshake something significant, but proximity. In Ramirez, the person was a good distance away.
A good distance
right?
away.
Here he came up. The word badgering is her word, right? That's in the police report?
That's her word. That's in the police report. And I think, again, there's an inference that he had followed her. In Ramirez, I think it was significant, the court held, that there was no evidence that he had followed her or come near her at all, made a physical touch or restricted her movement in any way, while he has touching her hand.
To Judge Grant's question about, do we really have a reasonable inference that he followed her? She infers, the victim infers that she was followed, right?
I think you have a reasonable inference that he followed her from Market Basket that day where he had seen her and was looking at her, and then he's coming up behind her. I mean, you're at probable cause right now, and obviously a lot of these things would be fleshed out at trial. I mean, we have to remember that.
I wanted to ask, there's language in Cho and Ramirez that says an expression of intention to inflict a crime on another, or an explicit statement of an intention to cause harm. Does the statement have to refer to I'm going to commit a crime against you, I'm going to harm you, or is it just intention to make a statement, and the statement could be understood that way?
I think it's intention
It's sort
to
of
make,
like a general
right.
versus specific intent.
I think it's an intention to make a statement and could be inferred that way. I mean, here, the intent, I think the fear was that he could want to have unwanted sexual contact with an underage girl. That's a crime, and
What do we know, where do we know from the cases that one does not have to express an intent to inflict a crime on another in order to make out the elements of...
well, it doesn't have to be explicit. It can be explicit. You don't have to make an explicit threat saying, I'm going to do X, Y, and Z to you. It can be implicit based on their conduct and actions.
But Ramirez says there must be an explicit statement of an intention to cause harm. That's what's hanging me up. I'm sorry, maybe that's in Cho.
In Sullivan, it says, even absent an explicit, and that's at page 28 through 29, it says, even absent an explicit threat of an intention to harm the victim, as long as the circumstances support the victim's fearful or apprehensive response. So you don't need an explicit statement, and that's in Sullivan. I mean, there has to be the intention to,
Case law that there has to be the intention.
yes, there does.
To do what? Are there cases on what the intent element is? Is it a general intent or a specific intent crime?
I'm not entirely sure. I don't have it off the top of my head to answer your question. I don't want to
That's all
give
right.
a wrong answer.
I looked and I didn't find them. And some of this is tied up in First Amendment law too. Because there's a question, if we're talking about the threat part of this, maybe there's a First Amendment component to it. And there's a recent case that suggests scienter is required. Or, well, I'm sorry, the recent case says recklessness is enough. Sorry. All right, anyway.
At the probable cause stage, when we think about whether a reasonable person would have interpreted the defendant's conduct and statements as a threat, are we talking about a reasonable 15-year-old girl or a reasonable person in general?
I think it would be a reasonable 15-year-old girl, and I would point to Ramirez for that conclusion. In Ramirez at page, I just want to make sure I'm giving you the correct page, Your Honor. Page 16, I believe, it says, and we must evaluate whether there was sufficient evidence to find that the defendant's conduct was threatening or physically offensive to a young woman. In that case, it was a young woman. So I would suggest that's what we're looking at.
Certainly where he tells her, where she tells him, I'm 15, why would we evaluate it on any basis other than his knowledge of what a reasonable 15-year-old might feel, right?
Correct. I mean, and that's what the court should do. If the court has no further questions, I'm happy to rest on my brief.
I did have one further question. Was there any argument made below that his use of, the defendant's use of a name that appears not to be his real name gives rise to any reasonable inference that's relevant to any of the elements?
There wasn't, Your Honor, at the hearing.
Okay. Thank you.
Thank you very much.
Good morning, and may it please the court. I'm Nancy Dahlberg on behalf of Blake Cadet, and we are asking the court to affirm the order of the judge in the Haverhill District Court dismissing the complaint.
Excuse me, counsel, could you just try to lean a little closer to the...
Will do.
Or stretch that metal thing up as close as...
I will talk louder, which I'm capable of. Nancy Dahlberg on behalf of Blake Cadet, asking the court to affirm the order of the judge in Haverhill District Court dismissing the complaint for lack of probable cause in the application. I appreciate the questions of the court, obviously very reflective of everything that we've submitted. Let me, as the court has divined, the issue of probable cause as to disorderly conduct and offensive conduct are at issue here. And I would just like to start here by saying that the inferences that the Commonwealth tries to draw in order to put this case in the context of Sullivan or Cahill or Joe, I think are without merit. There is no evidence that Mr. Cadet followed the complainant. And I believe, so I believe the court can take judicial notice of the fact that the two addresses that are provided in the police report are about a third of a mile apart, if we trust Google directions, which I generally do.
And that's helpful, I suppose. We can look at a map. But it's probable cause. And what your opponent is saying is, it doesn't have to all be shown here, right? So the 15-year-old girl expressed to the police officer that she felt she was followed. And does the Commonwealth have the opportunity, perhaps, to prove that at trial, where he did see her before, then he saw her shortly afterwards, a third of a mile apart? Is there enough so that at probable cause stage, Commonwealth gets to take a shot at proving that it was a following situation?
And my answer, not surprisingly, is no, because this is a little unusual, and there are two police reports, and they're quite detailed. So the complainant and her mother go to the police station the first day, and they go back the second day, and there are details added on the second day. So the expectation that there would be anything else coming forward at trial is really unlikely.
What about the part of the report that says your client also has a history of similar incidents? See incident number 23 and then a bunch of other numbers. Does the Commonwealth, is it possible the Commonwealth has a prior bad act that they want to admit at trial?
I don't think those would be admissible. We don't know what they are. They
What
weren't
if they are that he
included.
regularly follows 15-year-old girls from one place to another? Wouldn't that come in as an MO? And wouldn't that make a huge difference?
There's absolutely no evidence of that
But
here.
there
That-
is something in the police reports that suggests he has a prior history, and we're at probable cause.
That's the assertion made by the police officer without any specificity. It can't be considered for this. I would submit can't be
We're talking about the light most
considered.
favorable to the Commonwealth.
Even in the light most favorable to the Commonwealth, we don't, that's a very vague statement. We don't know what it means. It's very unlikely.
Why we need a trial?
I'm sorry.
It's a very vague statement. We don't know what it means.
Yes.
We don't know from this record that these two locations are a third of a mile apart. We also don't know how many turns somebody has to make to get from one to the other, or how well-traveled the route is. Isn't that why we need a trial?
I would say no. The distance between these 2 points, which is apparently, according to the complainant, the route that she walks home. So we know that this is a well-traveled route by many people. It's Haverhill Center, so people are shopping there, and remember, back in front of the dollar store an hour after shopping. But a vague statement that there's some prior incidents would not support probable cause here. We don't know what they are, we don't know if they're valid allegations, and we don't know that they would come in. In fact, you know, it's just as likely that they would not. But the other allegations that the Commonwealth makes about
Does
Yeah.
evidence in a police report have to be admissible at trial in order to contribute to a probable cause? I mean, this is all hearsay, right?
I would say no,
This is admissible.
but this is not evidence. It's a vague statement that there's similar conduct. That's all we
He has a
know.
history of similar incidents. See incident number, whatever.
Yes, and we don't,
23, and this is May, so it starts with the 23. Can we take judicial notice that the previous incident was within the past 5 months?
I would say that's not specific information. The judicial notice on the distance and what the complainant says about the route, I believe, you know, can be considered by the court.
So what's your view on whether there needs to be an express intention to do harm in so many words or commit a crime in so many words versus merely an intention to do an act which may constitute a crime or cause harm?
I think as the Justice rightly pointed out, I believe it is Ramirez that talks about, and that could be also quoting another case, an expression of an intention to commit a crime. So there is an expression of intention required.
If you say, I'm going to make beautiful love to you even though you're 15 years old and you're going to like it and I'll take my time with you. I don't hear an intention to commit a crime there. I don't hear an intention to do harm there expressed specifically. And you're saying that that wouldn't be enough. He has to say, I'm going to sexually assault you, or I'm going to have sex with you against your will, or I'm going to hurt you. That's required?
Well, certainly an expression of an intention to commit a crime, which is not done here. And may I say that the Commonwealth cites Sullivan. Sullivan is a case in which, although the defendant didn't make statements except get in the car, his conduct bristled with menace, as the court described it.
But the problem is in both Sullivan and Cahill, we held that the evidence of annoying and accosting was not sufficient even after trial because the threat was not explicit enough. And in both cases, the SJC reversed us, saying it doesn't have to be an explicit threat. So what do we do with that? It sounds like you're setting us up to be reversed again.
The conduct in those cases was clearly hostile and angry. It was a threat. It was an expression of an intent to commit a crime against the complainant. And the purpose was to do harm. And this, again, as Justice Englander mentioned, gets into the true threat First Amendment question.
So as long as the defendant thinks that the victim is going to say, "Oh, sweet mystery of life, at last I've found you," to quote a movie, and she's going to love it, then it's not annoying and accosting?
It's not a threat to commit harm.
What do we do with Judge McHugh's statement in Moran? A stranger's unbidden suggestion of sexual activity is inherently menacing, for it invades a very private zone.
So in Moran, you know, the defendant walked over to the nanny in close proximity and mimicked masturbation. So by his conduct, he expressed an intention to commit a crime against the nanny.
Well, isn't asking her out multiple times after she said she's 15 and asked him to leave her alone, and saying more than once that he has a car and that he'll take his time with her, doesn't that amount to an unbidden suggestion of sexual activity?
I would say no, it does not. He did not follow her into the store. He did not ask her to get in the car. He did not ask where she lived. When he sent her a text message, it was a picture of Minnie Mouse sneakers. So while he may have had a misguided interest in some kind of non-sexual romantic relationship with this girl, there's no suggestion that his conduct or statements indicated an intention to have sex with her.
So he's 30 years old. She's 15. She's underage. He repeatedly asks her, he says that this is our first date. He repeatedly asks her on dates. He badgers for her phone number. He immediately responds afterwards. He says, I'll take my time with you. And it is at the probable cause stage, as a matter of law, we cannot infer a sexual connotation to those acts. That's your position.
I would say that the evidence here does not present probable cause of an intention to commit sexual acts. It does intend, a misguided, apparently, intention to have some kind of a relationship, but it doesn't suggest sex, and it doesn't.
So people have dates just to be platonic friends? They don't have, dating doesn't imply a romantic and possibly sexual relationship?
There would not have been anything illegal about having a romantic relationship between these two people, however misguided by this gentleman. Sex under this, given 15-year-old, yes. But but with his conduct, shaking hands, the most civil thing you can do.
About the distinction between romantic and sex under the circumstances. It's a really fine line.
Well,
it seems to me.
It's an important line because all of the cases that talk about the sexual activity are very explicit. Joe is full of, the posters are full of sexual insults. Sullivan, it's clear what what the defendant was trying to do to the victim. Whiting, the fellow pulls up onto a driveway and, well, I won't use the language here, but you can check. Cahill, this guy asked the victim out over 20 times, got very angry when she rejected him, and then came up behind her and grabbed her and said, I love you.
There are other cases where the evidence is worse.
All of those cases are much worse. This case really, truly is much similar to Ramirez.
How many of those are probable cause cases versus sufficiency cases?
I'm sorry.
How many of those cases you just recited are probable cause cases versus sufficiency?
None of them. But, this is a small universe of cases, and so often happens we don't have other cases.
If the victim inferred that if she didn't give him a phone number, he'd become angry at her, doesn't that contribute to probable cause?
He did not give her any reason to think so. And by the way, there's no evidence that he approached her from behind. Again, I think the Commonwealth is trying to put this in a box with.
The report says she turned around.
Yes, so she heard
Market. That she was approached from behind.
She's heard someone say, hey, Market Basket Girl. She turns around and he approaches her from some undetermined, some direction. And then, afterwards he goes into the dollar store. And so there are shops here. There are people shopping. There's no indication that there was no one around, that this was an isolated place. Clearly there were people working in the shop. So the suggestion that he was stalking her.
Would it make a material difference in your analysis if, in fact, there were a reasonable inference that he followed her from the market basket?
I think if he followed her from the market basket, if that were a reasonable inference, it would not be helpful to this analysis. I don't know if it would
not be helpful.
It would not be helpful, no. But there's no inference here. This is a shopping area. This is on her way home. It's Main Street.
I'm wondering whether there's at least an inference for probable cause purposes from the fact that he saw her at Market Basket. She knows he saw her at Market Basket, and then he sees her as she's walking home within hours.
within an hour
of a
that,
mile away. I mean, isn't there a reasonable inference he followed her?
I would say absolutely not. I think there's a reasonable inference that this is a shopping area, that he was shopping, that he saw her and said, hey,
Just-
Market Basket Girl.
So
If
that
he-
might be a reasonable inference, that he just happened to run into her. It might also be a reasonable inference that he followed her. Which one counts for probable
He
cause
followed her
purposes?
before, as the victim inferred. In the police report says, the victim stated the only reason the defendant knew that was the route she took was if he had watched her before.
Yes, and that is not a reasonable inference, I would submit. There's no basis for that. I just want to get
So
back
the
to
victim wasn't being reasonable? What should the victim have done in this situation?
the complainant here. There is no complaint currently. Listen, no one's going to blame this girl for being afraid. We're all afraid, and she's a girl. She went home and talked to her mother, and she was maybe have been afraid at the time, although she's told the police on the day that there were no sexual statements made to her, no suggestion of sexual activity.
Then it also
But
says
she's
she
forever
believed...
stuck with, sorry, go ahead.
No.
She said to the detective, the victim stated she believed the defendant wanted to do sexual things to her body. So which of those do we believe in the light most favorable to the Commonwealth?
Well, she said something on one day, and the next day she said something else. They're both valid. She was afraid, and no one wants her to be afraid. I did want to mention with Ramirez is very instructive here, because the first day when again, the defendant, there was no annoying and accosting in that case, even though he was originally convicted. So the defendant is seen staring at the girl in the pool, which is not the case here, although the Commonwealth, I think, uses the word staring, and wants to know why she's leaving. She's a 7th grader. The next day, he shows up, apparently for the first time, in her neighborhood, across the street, watches her as she goes to a store and says, what kind of candy are you going to get? And when she comes back, he comes outside and sings a song to her that he's falling in love with a little girl. And then she goes across the street and he watches her. So that gentleman knows where she lives. She's uncomfortable, but that did not qualify for...
Isn't there an inference? He's inside the house the first time that he calls out to her, right? So there's an inference that he has a rightful place where he is.
I wouldn't draw that inference myself, but he goes to the window, he sticks his head out the window, and when she comes back, I did read the case again, I believe he's outside.
He is outside when she comes back.
Yes,
That's
so
correct.
he's come outside, she's coming back, and that is not enough.
Okay.
All right, thank you.
Thank you very much.
Our next case is number 23P909, Commonwealth versus Derek. I'm going to take a crack at this, MANCEVICE, and counsel will help you correct me if I'm wrong. Whenever you're ready.
Good morning. May it please the court. Caroline Howe on behalf of Mr. MANCEVICE. There are 3 issues before the court
Use your
today.
closing argument voice. The people in the back row need to hear you.
There are 3 issues before the court today, and I'd like to focus on the Bruin issue first. Bruin says that excessive discretion by a licensing authority, whether it be for proper cause or suitability, is unconstitutional.
Bruin, so we're going to have a debate about this, because I read Bruin pretty carefully, and I don't see that that's true. I see Bruin saying proper cause is unconstitutional, but suitability may well be constitutional.
I
So
think
what am I
that's,
missing? Because, there are other statutes out there that have some sort of discretion, and that the court in that original footnote seems to suggest may be okay.
I think that's right. I think that suitability provisions are not wholesale unconstitutional, and I think even discretion when it comes to suitability provisions are not unconstitutional wholesale, and that's what the court was saying. There are 43 shell-issue states,
Okay, but
and their
I thought I
statutes
just
are
heard you say
constitutional.
differently in your opening sentence, so I want to get on the same
Excessive discretion.
page. I think now we're on the same page, which is suitability may be constitutional.
Right, and excessive discretion when it comes to the licensing authority, who's the executive, That's what makes a suitability provision unconstitutional, and that's what makes a may issue provision unconstitutional. And we
And
know that
again,
from...
we may be on the same page.
Why is may issue even an issue here? He had a license.
Right, and then his license was suspended
Okay.
under the unsuitability provision.
Doesn't
Okay,
the
so-
reason-
So why are we talking about may issue and whether we are a may issue state? The issue is his suspension, not whether he may get a license in the first place.
But also whether he may have his license suspended, and that's 131F. So 131F says you may have your license suspended if...
Okay, and that depends on
Based
whether
on
the...
suitability. Sorry.
Exactly.
I mean,
That's
so
exactly right.
let's talk about, if you're going to bring a constitutional challenge, let's talk about the suitability and the discretion, which I didn't see a great deal of in your brief, actually. I saw a lot about we're a may issue state, therefore Bruin says this statute is unconstitutional, and
Right.
that doesn't seem to be your position now, or my understanding, or
So it is the same, and that's because 131D and 131F handled both a licensing scheme where you are granted a license and also where your license may be suspended. And that's 131F. It says your license may be suspended. But if a licensing authority has discretion, and we know from the First Amendment
But
context...
discretion is not, you've just said, and I agree with you on my reading of Bruin, discretion is not enough,
Right.
okay? As long as the discretion is bounded by objective criteria. So doesn't it matter, and this is a question I'm going to ask to both of you because it's not really addressed in the briefs at any depth, doesn't it matter why it was suspended?
I think when it comes to a licensing, a suitability provision that is a narrow, objective, and definite, then yes. But in 2018, we had a suitability provision that was not bounded by narrow, objective, and definite
You'd been
criteria.
convicted of a crime, been convicted of a felony. Suitability says it could be revoked, constitutional or not?
So that's a prohibited person statute, and that's a different part of 131D.
I'm just talking about, would that make him unsuitable? He'd been convicted of a crime.
As long as the discretion granted to the licensing authority is bounded by narrow, objective, and definite standards, then yes.
Okay.
But if it is not, then...
Well, here he's charged with a crime, witness intimidation, right? But that's not enough?
In 2018, when it was a may issue statute, no, because there was too much discretion granted to the executive.
Aren't we doing this at, why would we look at this on its face? Why wouldn't we look at it as applied to your client? And as applied to your client, the license was revoked based on the fact that he was charged with a felony, witness intimidation.
in an incident in which he was in a physical altercation with another man and he brandished a firearm.
But those are two different incidents.
Those are two
that
different
happened
charges,
weeks apart.
both of which were dismissed by the Commonwealth. So he's
4 years
not,
later,
he's not a convicted felon.
4 years later? They were
Sorry?
dismissed 4 years later.
Yes, Your Honor.
But at the time that the police revoked his license, he was subject to a witness intimidation
Yes,
charge.
that's correct.
Okay.
But in 2018, and this is what I think Bruin contemplates when they take issue with may issue statutes, is if you are giving the executive too much discretion to say you, not you, are a suitable person. I like you, I don't like you, you're a suitable person. That's too much discretion. And we know this from the First Amendment context. In Shuttlesworth, we don't like...
It's not a First Amendment case, and the First Amendment overbreadth cases have, at least for this person who learned a lot of constitutional law 40 years ago, you may be able to correct me, First Amendment has always been treated differently with respect to overbreadth.
But in the Bruin majority, they do cite to the First Amendment. They do cite to Shuttlesworth. And that's where I'm getting this narrow, objective,
Bruin, you
and
mean?
definite language. In Bruin, the Bruin majority, they're citing to the First Amendment context saying, we don't like the executive having too much discretion when it comes to the exercise of constitutional rights. We know this from the First Amendment context. In the Second Amendment context, these may issue statutes simply went too far. We need
Oh, because-
reasonable
So your argument
boundaries.
is a facial argument, not an as-applied argument?
Both.
It's both.
Yes, Your Honor.
And that's the way it was presented below?
Yes, Your Honor. There was two motions. There was a renewed motion to dismiss when Bruin came out, and then a motion for required finding.
What do you say to your opponent's statement in their brief that you didn't raise the argument you're raising now?
I think that there was very clearly from the language of the two motions, the suitability provision was quoted and a Second Amendment challenge was raised, and that's enough to put the motion judge and the trial judge on
Second Amendment
notice.
challenge was raised, but it was different than the one you're making now.
I think there were multiple Second Amendment challenges, and one was to the constitutionality of the criminal statute, but underpinning the criminal conviction is this suitability provision, and that was quoted both times in both motions. And we want to put the motion judge and the trial judge on notice about the arguments being raised, and I think that's what happened here. But I think going back to the May issue scheme here, it's not that discretion is bad, and I would agree with the Commonwealth, again, that suitability provisions are okay, and contemplating what shall issue statutes are going to look like going forward is a job for our legislators. But in 2018, we know that Mr. MANCEVICE's license was suspended under a statute that just simply gave the executive too much
But were
discretion.
the particular reasons for his suspension in excess of what is constitutionally permissible?
We don't know, and that's the problem, because it was a May issue. They may have suspended the license because he was an unsuitable person, but that discretion makes it unknowable, essentially.
I want to
I
understand.
don't quite get that.
I want to understand your argument about Adams, because you
Oh, yeah.
rely on it a lot, but there's one sentence in Adams that you don't seem to quote that seems to be problematic for you. The SJC said, although the statute is less than clear, the legislature could not have intended to permit firearms to remain in the possession of dangerous individuals during a 90-day appeal period and then during the possibly lengthy duration of any subsequent appeal. As I understand the Adams's interpretation of the statutory scheme, it gave the chief discretion to let someone keep their firearms and turn them over to someone else. But this chief, in his discretion, said, if you want to do that, you've got to turn them into us first. And you're saying somehow under Adams and that sentence, that was improper?
So Adams provided for two categories, and one is the immediate surrender category. And in that category, I think you're absolutely right. Anybody who's deemed dangerous by the police chief can have their weapons taken away during that appeal period. But there's a second category, and that's the compromise Adams struck between 129D and 131F. And in that category, the commencing of an appeal stays that obligation, and it's the discretion of the police chief to decide who is in the side.
So here there was no appeal commenced.
No,
There
Your
may have
Honor.
been some uncertainty, and these events all occurred before Adams.
Yes,
Correct?
Mr. MANCEVICE was arrested before. Yeah.
So at that time, and still, 129D requires a defendant to turn in the firearms or the ammunition or whatever without delay.
Mm-hmm.
Now, Adams is about what is the consequence of whether an appeal is filed, whether a request for judicial review is filed. But it doesn't change the fact that before a request for judicial review is filed, you have an obligation to turn in your firearms and your ammunition without delay.
So
Do we agree on that much?
With a caveat, that I think the second category allows for the commencing of an appeal to stay the obligation to surrender firearms.
Okay, but but before an appeal is commenced, the obligation is to turn them in without delay.
Again, I would say that in order to commence an appeal, you have to have the opportunity to commence an appeal. And so I think under that second category, a person would actually have 90 days to commence that appeal, which is the appeals period.
So there's some suggestion in the brief that the defendant had already contacted a lawyer and was waiting for the lawyer to return his call, citing Record Appendix either 17 or 27. But I don't see that at the cited page. I can't find any evidence that he had called a lawyer, let alone what the call was about.
It should be in the defendant's original motion to dismiss. But he told police that he had attempted to call his lawyer before he turned in his ammunition. But I think all that goes to the fact that you have to have that opportunity to.
You say
commence
that's
an
90
appeal.
days?
I would say for the second category, again, that's where there's no
For the
immediate.
second category. And he falls into the second category because?
Because a letter was sent to his home that took 10 days to reach him. Police were not knocking on his door on that 10th day when he received the letter. Instead, they waited for him to show up to the police station 4 days after that.
Even though the
And then
letter
he
said, turn it in without delay.
And I think that goes to my second argument, that without delay is unconstitutionally vague. I mean, if it really meant immediately or right away, then
Doesn't the SJC treat them as equivalent in the Adams case? Without delay and immediately? It
think
seems
they're
like they
getting
use them interchangeably.
I think the without delay language is coming from the statute.
Yes.
But I think that it's still unconstitutionally vague because we don't know when criminal liability attached to Mr. Mancevice's actions. I mean, if it really was right away.
Let me just back up. Does the SJC use them interchangeably so that without delay means immediately? And
I mean, maybe that was the intention, but I think it's unclear, and I think reasonable people can disagree about it, what it means. And I think that's part of the problem when you have discretion given to prosecutors and judges and juries to figure out what these terms mean.
Assume that without delay means immediately. What does that do to your argument under Adams?
I mean, I think it's undermined by the simple facts of the case. The jury acquitted him of possession of an FID card, which he turned in 5 days after he received his letter.
So if you want us to construe the statute to mean that if police have information that somebody has an arsenal of guns in their house and they're an inappropriate person to have a license and the chief wants to suspend their license, that the police have to show up at the house with a SWAT team to get the guns. They can't just safely mail a letter and say, turn them in without delay?
I mean, I wouldn't say that Adams says that the only way that immediate surrender can be effected is through showing up at the person's house, but we certainly know from Adams that that is the one set of circumstances that does mean immediate surrender. But sending a letter and then waiting days for a person to self-report to a police station, not once but twice, and not arresting them either time, and waiting till after.
Wasn't it over the weekend? So you say it's 5 days, but I think there was a weekend in there, right? So, I mean, he's like 2 days late. Is that right?
I mean, I think under that interpretation of immediately or right away, but again, reasonable people can disagree about what it means, and the jury certainly disagreed that he hadn't turned in his FID card without delay.
The police could very well have felt that he didn't do it without delay, but they weren't going to make a big deal about it because he showed up in 5 days. But then it turns out he didn't give them everything. So they went and got a search warrant.
I mean, perhaps, but again, I think it's that lack of certainty. We want notice and definiteness when we come to criminal statutes. We don't want guesswork. We don't want reasonable people disagreeing. And the jury's disagreement with the FID card versus the possession of ammunition, I think, indicates that this is a confusing area.
Can I switch back for a moment and just ask, my memory is that the suitability requirement in the statute is subject to some objectively limiting case law, isn't it? And was at the time?
The suitability provision in Massachusetts?
Yes.
Are you Holden, for example?
It's not in the briefs, and I didn't go back and look, but this is my memory, that suitability has been defined and objectively limited.
I think the Bruin Court disagreed, and they disagreed very explicitly. They said
the Bruin Court was talking about a cause requirement.
They were talking about both. They say in the context of these 6 may issue states has not demonstrated cause or suitability. They say it very explicitly. So I think it is, in fact, both, that that's in the majority opinion. I think they're talking both about proper cause and suitability. And that's why they're talking about discretion, because proper cause is never okay, whether or not it's discretionary. But these suitability provisions are problematic if they're too discretionary.
And you're saying that Bruin decided that the Massachusetts statute, suitability provision of the Massachusetts statute is not good enough?
They say it explicitly.
Where? In
They say
footnote
it's
1?
page 14. It's in the majority opinion, page 14, or depending on the reporter, 2124. It's very explicit. They say
Page 14.
there was a cause, a good cause, reason to fear
yes.
standard in the Massachusetts statute at
both.
that time that they referred to. I didn't.
Exactly. It was both. It was both that there was good cause, which has been stricken, but it was also may language, which has also been stricken and replaced with shall issue language in the suitability provision by the legislature.
Can I just go back to the issue of whether he was consulting a lawyer? So Record Appendix 27, that motion that you cited, does cite to the report of Sergeant Ricos, I think. But I don't find Sergeant Ricos's report anywhere in the record. All I see is the memo of law. So if that's there, could you let us know where it is?
Yes, Your Honor. Thank you. I would ask that you.
I have
Thank you.
a couple of questions. In the record appendix, the chief's letter and the defendant's license to carry or FID card and the certified mail, those don't have exhibit stickers on them. But the transcript says they're marked as exhibits, and it looks as though they're marked as 3 separate exhibits, and in the record appendix, 2 of them are on the same page. Are these from the clerk's papers, or are they
Yes, Your
from
Honor.
your file?
They're from the clerk's papers, Your Honor.
And it doesn't, even though it said so marked, that nobody wrote Exhibit 4 on it or whatever, even though the transcript says so marked?
I couldn't see it. But this is what I got from the
Okay.
trial court in Barry.
Okay,
I
thank
would
you.
ask that Mr.
And I
MANCEVICE.
have a couple questions, I'm sorry. We haven't even touched on the ammunition argument. Are you still pursuing the argument that there was insufficient evidence that this was ammunition?
I am, Your Honor.
Okay. If the ammunition itself is in evidence, as it was, right?
Yes.
Ammunition is putting the rabbit in the hat, but the materials were in evidence. Why isn't that enough?
I don't think that there is a jury in the Commonwealth who could look at a piece of, say it's ammunition, a piece of seized item, and say, I know for beyond a reasonable doubt that this meets the legal definition of ammunition. This is designed for use in a firearm, and that's because you have replica ammunition.
What about the box?
So I understand the prosecutor's closing argument references a box.
But and apparently, the transcript says the items seized were put in a bag and marked. So those are in the clerk's office.
Right.
But we don't have them. So we should decide sight unseen that the jury couldn't look at this box and these bullets and what's in that bag, that the jury could not infer that they're bullets. What if they say 9mm on them?
I don't really think it matters what they say, because even if they said that they purported to be ammunition that met the legal definition of ammunition, just because something is in a box that says it's what it is doesn't make it that
Well,
thing.
you
So
can
say
open
you
the
have,
box and see what's inside.
right, but I don't think that a jury, a average juror person
So
could
You have
look
to have
at it.
expert testimony?
No. The case law does not say you need expert testimony, but
Then
you
if
need
it's not,
some.
It seems to me that I only know of 2 different types of testimony, lay testimony and expert testimony. You're saying that the jury, as lay people, can't make the decision. So it seems to me you're saying it has to be expert testimony.
No, Your Honor, because the case law says that the testimony of a police officer is sufficient, but there needs to be some evidence. Say that the gun is loaded, and so we know that this caliber bullet fits in this caliber firearm, or this caliber bullet was found in a bag as the same caliber gun, and you have some police officer testimony saying, I have familiarity with firearms. Absent that,
The jury can't open a box that says on it 9mm cartridges, look at it and conclude that that meets the definition of ammunition?
I mean, I think it would be similar to opening a bottle of Advil and saying, I know that this, beyond a reasonable doubt, is Advil in this bottle. I don't see that you can do that. I think that you need some...
Case that says the jury can't do that?
It's cited in my reply brief. But I
There
think...
is a case that says that?
Yes, Your Honor. I mean, obviously, in the context of pills, you do need expert testimonies, having done a chemical analysis. But I think this case is...
I'll take a look.
Did the motion in limine preclude the police from using the word ammunition, or did it preclude them from testifying that the items met the statutory definition of ammunition? In other words, that they were designed for use?
I think the second one, Your Honor, and I think the reason the objection happened is because the defense attorney was worried that's the direction it was going in. But I think you see from DePina and McCollum that an officer can absolutely testify, this is a bullet, it's the same caliber as this firearm, and that's how I know it's designed for use in the firearm. But a jury is not to be given a legal conclusion. They're to
What do
be
we
given...
do with the defendant's statements that came in through the police, that when they said, why didn't you turn over the ammunition, he said something like, well, I couldn't find all these little bits and pieces?
I mean, I don't think that that is evidence that it meets the legal definition of ammunition.
Not an admission?
I don't think that that's, again, sufficient evidence that it meets the legal definition of ammunition because it needs to be designed for use in a firearm. It could be replica, it could be for a toy gun, it could be for another weapon. There needs to be some testimony by a police officer, and I think that's what the case law clearly says. It doesn't need to be expert testimony, but it needs to be some testimony guiding the jurors who, as lay people, may not know what meets the legal definition. I would ask that you reverse Mr. MANCEVICE's conviction. Thank you.
Thank you. Hear from the Commonwealth.
Good morning. May it please the Court, Donna Marie Herron, Assistant District Attorney representing the Commonwealth. I ask this Court to affirm the defendant's conviction where the claim he raises on direct appeal was not raised below, where his applied-to challenge is not properly before this Court, and where his unpreserved facial challenge did not create a substantial risk of miscarriage of justice, since the Bruin case, if you read it, it clearly states that what the Bruin court found unconstitutional was the proper cause, show cause standard.
Your sister says that I can go to page 14, I'm going to find out that the court has said that Massachusetts suitability requirement is unconstitutional.
And you're wrong. That's not what Bruin says. Bruin says the part of the Massachusetts statute that required above showing that you are a responsible, legal, law-abiding citizen, you had to also show a need, a specialized need or a specialized cause for wanting a license to carry. And it was that specialized, proper cause, good reason that was unconstitutional because it gave over discretion to the licensing commission, because you could meet all the criteria to be a suitable person, but you could still, the commissioner or the licensing commissioner could still deny you a license to carry if you could not prove why you wanted the license to carry. And
what case would I go to find the objective criteria for what is suitable person in Massachusetts?
You can look in Bruin, because Bruin drops a footnote and lists 3 states that have may issue in their statute, but they still found constitutional and qualified as a shall issue state. And they're using the shall issue and the may issue to differentiate between the 2 states.
Talking about footnote 1?
Yes, and if you look at Connecticut statute, you look at Rhode Island statute, and you look at Delaware statute.
If you let me finish.
Sorry.
I don't know that I can read footnote 1 as broadly as you want. My question was different. Where can I go in the Massachusetts law to find the case that's going to give objective criteria to suitability requirement?
I believe the Holden
Okay.
case
Yeah,
does.
I'm familiar with it.
I believe if you look at the statute too, as which the defendant was convicted under, it lists, give me 1 second, please. And again, I suggest if you please read the Connecticut statute, the Rhode Island statute, they are may issue with suitability determinations, which the court specifically in footnote said did not put them in the same category as the Massachusetts, New York, that was unconstitutional. But if you look at the statute in which the defendant was convicted under, it lists a criteria as to what, by clear and convincing evidence that the defendant poses, I'm quoting because I'm not quoting, I'm paraphrasing, a clear convincing evidence that the defendant, or that the license to carry poses a danger to the public safety. So there is a criteria that they have to meet. So it's not unbridled discretion to whether to suspend someone's license.
You said that you've argued that the constitutional claim isn't properly before us because basically he can't defend a criminal charge on the ground that the statute is unconstitutional. He had to go seek civil judicial review of the suspension.
Yes, Your Honor. That's what the people in Bruin, I don't want to call them defendants, the plaintiffs in Bruin did. The plaintiffs in Bruin applied for a license to carry, were denied, and then appealed that up. And then I sent
Okay, but just because they did it that way, does that mean that a defendant in this Commonwealth who's charged under a statute can't, and has a civil mechanism for challenging that statute or that statutory scheme, can't defend against a criminal charge because the person didn't invoke that civil challenge mechanism? I mean, are they exclusive?
I do believe that the Powell case, I don't think Bruin overruled the Powell case, which states you can't violate a statute and then challenge the constitutionality as applied. You can do a facial challenge, but you can't do it. And if I may say, also United States VESPRINI, which I sent this court, the United States Supreme Court there, that defendant violated the statute and then challenged it, and the United States Supreme Court took that as a facial challenge, not as an applied to challenge, but as a facial challenge. So I would suggest...
That's probably because I have to read Rahimi and apologize that I didn't get to it, but it's probably because that's the way the case was presented to them. I mean, your argument is basically an exhaustion argument, and I had the same question that Judge Sachs has, which is, look, they've been charged with a crime. Why can't they raise, as a defense to that, the statute under which you're claiming that I committed a crime is unconstitutional?
As you can, as a facial challenge. You can't do it I would suggest the law, Powell, the cases cited in the Commonwealth's brief, make it clear that has to be a facial challenge.
What is it? What is... What is is that a Mass SJC case?
Yes, Powell is a Massachusetts Supreme Judicial Court case.
So in Powell, the defendant never applied for a license, and I think he was underage, and he couldn't have gotten one, and he just sort of flouted the law and didn't ever seek to follow the licensing scheme. Here, the defendant had a license, it was suspended, and then, was it 6 days after he got notice of that, he faces a criminal charge. Are you saying he should have then, instead of defending the criminal charge, he should have pursued his licensing challenge?
I'm saying they gave a clear-cut way for this defendant to challenge his revocation of the suspension of his license, which is the 90-day appeal period.
And would that necessarily stay the criminal case? I mean,
No, not automatically, no, but
So he could be convicted before he ever gets a hearing in district court on his challenge to the license suspension.
I'm not saying he can't make any challenge. I'm just saying he can't make an applied-to challenge. And even if this defendant did
Is
make
there
an
any
applied...
case, whether it's Powell or Rahimi or Yakas or any of the cases you cite, that makes this distinction between a facial and an as-applied challenge that has to be raised civilly versus as a defense in the criminal case?
I relied on the Powell case, so I would say I used Levine versus, I cited a few cases in my brief, which I think stand for the proposition that you can't just violate a statute and then get an applied-to challenge. But even if this court disagrees with me...
How does that make sense? I mean,
Because
whatever you think of the statute and the Second Amendment, how does that make sense that you can't defend against a criminal charge on the ground that the statute under which you're charged, or at least a closely related, statute, inseparable statute, licensing statute, is unconstitutional?
I guess I'm differentiating what you mean by, I'm saying you can make a constitutional challenge, but I'm saying you cannot make an applied-to. You have to make a facial constitutional challenge.
If you could raise anything at that belated stage of being charged criminally, why wouldn't it be an as-applied challenge rather than a facial challenge?
Because if he had followed what was laid out in the statute, that you get this appeal period, then challenged it constitutionally, then the Attorney General's office would have been given an opportunity
The Attorney General's office only needs to be notified where the Commonwealth isn't otherwise a party in a civil case, and the Commonwealth is a party here, so.
But I would suggest that when you're challenging the constitutionality of a statute, the AG's office should be given as the chief. When their argument is this whole statute is unconstitutional, I think the AG's office should be given an opportunity
If that's in a civil case where the Commonwealth isn't otherwise a party, but district attorneys are given the responsibility to defend constitutional challenges against statutes in criminal cases.
But if this defendant had followed the rules and had filed an appeal from the revocation of the suspension of his license, then we would be in that position. But instead, he chose to violate the law. And I think Powell, and we can agree to disagree, stands for you can't just violate the law and then get all the benefits from it. I'm not saying he cannot make a constitutional challenge. He definitely can. I'm just saying that
he can't make this constitutional challenge.
He can, but he has to make a facial challenge.
And I think, frankly, I think the federal courts would have a different view of the notion that the state can prohibit a criminal, someone charged with a criminal case from raising a federal constitutional challenge to the crime. But anyway.
Even if we go into the applied-to challenge in this case, it still will be held constitutional for the reasons I stated, that Bruin struck down the part of the statute which required proper cause to why you needed a license to carry. The section in which the defendant's license to suspended does not touch upon that whatsoever. It gives it sets out a standard, which I finally found, I'm sorry for this, that says a determination of unsuitability is based on reliable and credible information that the application of licensee has exhibited or engaged in behavior that suggests may create a public risk to public safety. It's a set standard that they apply to determine whether someone is. The defendant, as we noted here, had threatened someone with a firearm, had picked up a felony charge, and under that statute, as applied, it was constitutional because it doesn't have the problematic language.
How do we know he threatened somebody with a firearm?
I thought that was in one of the motions to dismiss. I'll just say he was...
What I was able to find in the record is the reference in the letter to the statute under which he had been charged.
I believe it was one, and I don't have, it was in one of the motions to dismiss hearings that they were talking about this, and they were talking about the case and then how it got got dismissed. But I'll just rely on he committed a felony, because that's in the letter. He committed a felony of witness intimidation.
And it's in the search warrant affidavit about him brandishing the firearm.
Thank you. I did, that is where it was
Oh,
located. But
okay,
even
it's
just
in the
the witness intimidation, a felony, I believe that under the statute, as it exists, which Bruin, I suggest, does not invalidate, that as an applied-to challenge does fail.
You say that he didn't raise this argument below. What argument is it that you think they did raise below? They did raise a Second Amendment argument.
He definitely made a Second Amendment argument. His argument was, so prior to Bruin, he argued under Adams that he got the 90-day
Right.
thing. And then when Bruin comes down, he makes the argument that Bruin has invalidated, and I can quote what he exactly says it, the requirement to have a license to have ammunition is unconstitutional. And that was the argument he made. And if you look on page 8 of the motion to dismiss of the second hearing, he says, the question today really is whether requiring a firearms identification card as it applies to the defendant, but in general as well, is a legitimate Second Amendment restriction, and whether it's something that is the core Second Amendment conduct that does not have a historical analog, and so therefore it's unconstitutional regulation overall. That was his argument below, that to actually require someone to have a firearms identification card to possess ammunition violated the Second Amendment.
You think that's not sufficient to raise to the judge the notion that the suitability requirement?
I do not, I think those are two separate arguments. I don't think it's the exact same argument that would raise the concerns that this may issue, may revoke is unconstitutional. He's
Even
saying
if
that
it-
to require a license altogether is unconstitutional.
Even if it wasn't raised, don't we review for substantial risk?
Yes, and yes, you do violate.
And if the statute's unconstitutional for a ground that, on a ground that he didn't press below,
Yes,
do you think it would not be a substantial risk of miscarriage of justice?
if you found that the statute was unconstitutional, I do think that would be substantial risk of a miscarriage
Maybe
of
not on its
justice.
face. I don't see a substantial risk of miscarriage of justice if there's a facial problem, but not an as-applied problem.
I suggest in this case, there is no facial, it's not unconstitutionally facially applied or as applied. It is a constitutional statute.
I understand where you are, but I'm just making an observation, which is I don't know that it's a substantial risk of miscarriage of justice unless it's as applied unconstitutional.
I would agree with that statement, yes, Your Honor.
How is the Commonwealth prejudiced by the fact that, as you say, the defendant didn't more squarely raise the unsuitability argument below? Would the Commonwealth have put in more information about this brandishing event or the intimidation of a witness event? Do
Yes,
we know if they involve the same person?
I don't. From the record, I do not know. I know the witness intimidation from one of the transcripts was a neighbor. That's what that charge came in, because they talked about, because when he was talking about it got dismissed, they were talking about, no, in the first motion to dismiss, they were talking about the charges. To the brandishing the firearm, I do not have anything,
Do
other
we know if
information.
the intimidation of a witness involved a firearm or ammunition in any way from this record?
I'm not sure on this record it does. I know there was some argument over fireworks. I'm not quite sure what the exact underlying facts were. If I could sorry.
I want to talk about the ammunition issue, not the issue of whether the testimony was improper, but just the straight-up sufficiency of the evidence that it's ammunition.
I would suggest.
What would you argue is the evidence from which this jury could find that he possessed ammunition?
Sure. And first, I want to point to the Velez case and the Mendez case, which make it clear that the jury can rely on their everyday life experiences and common sense to determine.
In Velez, it's in the firearm itself. It's already loaded.
I know, but
Sure
the
looks
case.
like ammunition then, but here it's just strewn around the floor, right?
Well, first you have the officer testifying it's ammunition. He uses that word.
He
You
uses
have the
word,
jury
but
has
he doesn't
the.
give us any basis for why he thinks it's ammunition. He simply uses the word.
But that came into evidence in light most favorable to the Commonwealth. Also, the box, as it said, as the prosecutor argued, they admitted the exhibit was literally in the box, the ammunition box that came in, and that, and they had it before them. And I think that is in the light most favorable to the Commonwealth under the Velez case, under the Menendez case, that is sufficient to establish, because they say it is.
Box was in evidence?
Yes.
Okay. And it would be in the clerk's office or in the custody of the police and
Yes,
could
it-
be recovered if necessary?
Yes, because I do know the question that sometimes they do hand that back over to the police station, and the clerk's office itself does not keep firearms or
Could be with
ammunition.
the clerk's office, right?
or at the local police station, because I do think they have a policy not to keep
Sometimes
firearms at the
Weapons and
clerk's
drugs
office.
and things are
or
returned to a more
ammunition.
secure location.
And just real quick on the Adams issue, Adams' case has made it crystal clear, the SJC, that in order to, I'm sorry, my time is up, but that in order to, the two prongs for which that you can suspend a license is to immediately, without delay, or, quote, the commencement of an appeal. It could not be more crystal clear, stays the obligation to surrender.
And is in the process of getting a lawyer, or might even be on their way to the courthouse, and is in the process of getting a lawyer, or might even be on their way to the courthouse to file that, yet they haven't done it yet, and as long as they haven't done it, their possession of firearm or ammunition is unlawful.
Yes, and that was the exact claim that Adams raised, that the 90-day period should automatically stay, so I have an opportunity, and the court was like, we recognize that there's some structure, but you have to immediately, and I would suggest without delay is not unconstitutionally vague, or the commencement of appeal would stay the obligation. There was neither in this case.
So what is a defendant supposed to do, or a licensee supposed to do, when their license is suspended, they can't lawfully possess anymore until they commence judicial review, and they need to get a lawyer to do that?
I don't know the process of filing an appeal. I don't know if it is just a form that they fill out and then
It's a
they file a
complaint
petition.
that has to allege that will lead to an evidentiary hearing.
No, I don't know, but I don't know.
It's not just it's not, if you look at the statute, you can infer that it's not just a check the box.
No, but to actually commence the appeal, I don't know. But the SJC made it crystal clear, and this defendant did not commence any appeal. And that was the exact issue raised in Adams, and that's what the compromise they came from. And I would suggest he falls under the first category, because when he's told in a letter that you are to turn over all your firearms, licenses, ammunition without delay, which I would like to point out.
So we depend on the licensing authority to say either without delay or immediately, or if they don't say that, then the defendant is supposed to infer that despite that being a statutory requirement, the defendant actually has 90 days or can go.
I think if a defendant is told in a letter that without delay you have to turn over these things, they can't ignore that directive and say, well, maybe I'll file an appeal when they're told without delay to turn it over. And I just want to point out the defendant was asked by the police, what does without delay, what did you think without delay meant? And he said, quote, as soon as humanly possible. So this particular defendant knew exactly what.
And there's also, as I recall from reading it, there's a line that says in bold print, failure to turn this over is a crime.
It does, Your Honor. And the defendant could just not ignore that and violate the statute. If there's no further questions, the Commonwealth will rest on its brief. Thank you very much.
Thank you. Thank you both. Very interesting case, well argued on both sides. And our third case this morning is 23P 1372, Commonwealth versus MARYELLEN Vesperini.
Good morning, Your Honors. May it please the Court, Keith Sachs, no relation, different spelling, for Ms. Vesperini.
I had to check the family tree, Mr. Sachs.
Yeah, I was concerned myself. I'm here today, Your Honors, asking you to reverse the...
Telling him that you're concerned that you might be related to him could be taken a different way.
Yeah.
Which, a concern, well, anyway.
My concern is always full disclosure, no appearance of impropriety, right?
Right.
I'm here today, Your Honors, to ask you to reverse the Newbury District Court, Judge Doyle's denial of my client's motion to withdraw her quaff from April 14th, 2016 on a first OUI. And I'm asking you to do that, Your Honors, because I believe Judge Doyle did not analyze the issue under Hallinan, which came out in April of 23 from the SJC, properly. What I believe Judge Doyle did was improperly put evidence into the record of his belief of plea counsel's knowledge, and I believe he certainly didn't do the analysis of the admissible evidence and whether a reasonable person, knowing that the breathalyzer was inadmissible, would have still gone ahead with the quaff with the known admissible evidence. Now, I think...
Isn't the problem more that he analyzed all the admissible evidence, but he had some other things that you think he shouldn't have thought about?
Yeah, and I think the problem is, I guess, Your Honor, to say it easily or easiest, is that he didn't analyze the admissible evidence in and of itself and how it would impact the decision of Ms. Vesperini on that date. Because what the judge says, and I'm reading from the Commonwealth brief at page 17, where they quote the decision, says, the Commonwealth's case against the defendant is particularly strong without the breath test. And then he goes on, the erratic observations of the officer, performance on the FSTs, the breath test, and the field breath test all support a just result. So Judge Doyle never divorced that evidence from the analysis, right? What he didn't do was look at the field sobriety tests in and of themselves. And yes, like many police reports, there was the writing, glassy eyes, slurred speech. What Judge Doyle didn't analyze are the other field sobriety tests properly. He did not mention that both the backwards alphabet and the counting were performed by Ms. Vesperini with ease.
So this motion judge was also the plea judge, and therefore we owe him extra deference. If he had not mentioned all of these bits of evidence and considerations like taking judicial notice of knowledge of defense counsel or appearance in other cases that you say he shouldn't have, would there have been enough for him to, within his discretion, deny the motion?
No, I don't believe so. I don't believe the evidence before him was enough.
So you don't think that a remand to have him look at this using only the proper factors would be worthwhile, because even if he did that, he couldn't possibly reach the same result?
Yeah, I do not believe he
You're looking
could.
for an outright reversal?
Yeah, I am, Your Honor. And I don't think he could reach the same result. And I understand, Your Honor, as it relates to deference, but I do want to point out, I know the court is loath to hear about Rule 23 decisions, but in June of this year, this court, a three-judge panel, not Your Honors, did find exactly what I'm looking for in a same case. It's the case of the Commonwealth versus Schnupp, S-C-H-N-U-P-P. It's 104 Mass Court App 1110. And understandably, the
Same judge?
Excuse me, Your Honor?
Are you saying it was the same judge?
No, sorry. No, same issue. Same issue.
Is it the same set of facts?
Somewhat, yes. But I think, and I'm trying to, because of how the court feels about Rule 23s, I'm trying to stay away from the factual thing. But I think the most...
Well, I mean, there are a lot of these cases. I mean, I have one called Pagan. It's unpublished, and it decides that the judge properly refused to open a new trial. Facts aren't the same. I mean, we're going to get different sort of arrays of facts in each instance.
Yeah. And the reason I bring this case up, Your Honor, is it relates to the deference issue that a judge could be afforded. What it says in footnote 3 of the Schnupp case, it says, we do not ignore the judge's conclusion that the defendant's affidavit was self-serving or the principle that we extend special deference to a judge's decision, whereas here the motion judge is the same judge who presided over the defendant's admission. We nonetheless conclude that Hallinan constrains us to reverse.
What's the docket number on Schnapp, if you have it there?
That is 22P190, Your Honor.
Thank you.
So
You think we're constrained to reverse by Hallinan?
Excuse me, Your Honor, I'm
You
sorry.
think we're constrained to reverse by Hallinan? That's your argument, right?
Absolutely on these facts when we look at a reasonable person. And the facts here are even lighter.
Oh, I mean, isn't the big difference between this case and Hallinan that in Hallinan she was a second offender, she was going to get, she got nothing much from her plea because she got her license suspended for 2 years. Here, as the judge points out, because she was a first offender and she had the ability to do this process I'm not really familiar with, where she can say she's a hardship, she could get her license back in a day.
Absolutely, Your Honor.
That's a huge difference. I mean, shouldn't we give some deference to the judge's conclusion with respect to that factor?
Well, the difference, Your Honor, is that had she not pled at all, based on, with the blood alcohol not coming in, based on the thin evidence of impairment, she could have gone to trial and got a not guilty.
Well, maybe, but she could have gone to trial and got a not guilty while her license was suspended for what, a minimum of 45 days, or is it 90 days?
It's a minimum of 45 on a first.
Minimum of 45 days. We don't know. We don't have anything in here about her circumstances, whether she could, how well she could afford to have a 45-day suspension of her license at that time in connection with her work. There's nothing that tells us that this wasn't the decision she absolutely needed to make.
And Your Honor, the issue of benefit is but one of many of the
But it's a big difference from Hallinan. Will you give me that?
I will give you the difference in terms of the license and all that, but it's also a big difference in Hallinan insofar as what the facts were there. Here, and also like in the Schnupp case. In the Schnupp case where this court reversed, that gentleman had left the scene of an accident. The evidence of impairment outside of the blood alcohol level was far greater than it is here. All we have in this case is the glassy eyes, slurred speech, which I would suggest is probably in many police reports, and then passing two of the tests with ease, and then the court, for whatever reason, looks at the one-leg stand and the walk and turn as a miserable failure. Nowhere in the police report does it says this was a miserable failure.
It was a failure.
Excuse
right?
me? Yeah.
She was unable to follow the directions that she was given with respect to the walk and turn.
Yes, but I do believe by the judge saying, believing it's a miserable failure, that he's looking at the evidence in a different light than.
She admits that she had 2 drinks. She lies about how many drinks she has twice before she finally comes to the 2 drinks. She fails 2 FSTs. She doesn't have her lights on while she's driving at 9:30 at night. That isn't enough for her to be concerned that she might get convicted and wind up with whatever the suspension is that comes with that?
I don't believe so, but the problem, Your Honor, is she didn't have the opportunity, because we're talking about egregious government misconduct as it relates to the blood alcohol, right? So the day of it, she was told that that was coming in and she was likely going to get convicted.
Her affidavit says, at no time did my attorney even mention the possibility of challenging the Alka-Test 9510. But then the worksheet that the lawyer completed with her mentions the alcohol at the top, breath test, Alka-Test 9510.
Yeah.
And the judge took judicial notice of the fact that this same defense attorney was involved in the Ananias litigation.
And yeah, I see that, Your Honor. And the funny thing about that is the document, Appendix 26, that mentions the 9510, doesn't mention anything about I'm involved in this litigation.
But it does say that the result may not come in because there wasn't the observation period, and also the judge could permissibly not credit the defendant's affidavit and draw an inference from the absence of defense counsel's affidavit. Would you agree with that?
Well, certainly he can draw an inference, right? But I do think, based on what that footnote in Schnupp, that I think that inference and his discretion is overridden a bit.
Well,
but
again, that's a difference from Hallinan. In Hallinan, defense counsel put in an affidavit that said, had I known this, I would have advised her not to plead.
Sure, but it's not required, right? There's nothing that says it's required.
But an inference can be, certainly a motion is much weaker without it, and an adverse inference can be drawn, can't it?
No, and I don't agree with that, Your Honor, because the form that Attorney Waldman gave my client, the only thing it talked about was possibly dealing with the 9510 because of the requirement.
Granted, there's no specific evidence that he advised her about the calibration and the record-keeping issues. But he did advise her and that sheet documents it, that it was not a sure thing that the breath test results would come in. And nevertheless, she chose to plead.
Well,
Did that not get any weight?
well, I guess if you're discrediting her affidavit completely.
The judge, I mean, it's not up to me to decide, or us,
Yeah.
to decide whether it's credible. It's up to the judge, and he didn't credit it.
Yeah, but I don't think the form in and of itself, by saying we could challenge it, it may be inadmissible because of the issue related to the police not being present, is not enough in this case. If the judge himself is saying, which I don't think he can say, right? It's not judicial notice to say, I know what Attorney Waldbaum does. He knows about this stuff, right? So even if Attorney Waldbaum knew about that, why on that form is there not something that says, oh, and there's also the possibility that this could be taken out because of other cases?
What I'm suggesting as the adverse inference is not specifically that he did advise her about the Ananias issues, but that his affidavit would not be helpful to her. And we don't know on what basis it wouldn't be helpful, but...
No, we don't know. But what we do know is what is on that form. And there is nothing on that form.
And we know that she had at least constructive knowledge that she could challenge the admission of the breath test, and yet she pleaded, so.
Sure, but I don't think...
Can we go to your fundamental point, which is the judge can't think about the fact that he knows who her counsel was, and he's got in front of him, you know, a statement in an affidavit that says, I wasn't advised at all about my ability to challenge the breath test? I mean, why, does the judge required when he's charged with evaluating, he's charged with, under our case law, evaluating the credibility of what he's being told on a motion for new trial, right?
Correct.
And he knows that it is extremely unlikely that what he's just read is true. He's charged with ignoring that?
Yes, because that's not common sense. That's not judicial notice. That is evidence. That is the judge saying, I have evidence of Attorney Waldbaum's knowledge, and I'm going to use what I believe is evidence and use it against the client, even though it's not in the record, it's not subject to cross-examination or anything like that. It's no different than a judge.
But she has the burden, right? She's the one who's coming back 7 years after she stood up and said, yes, I did it. Yes, I had enough in my blood. But now you need to revoke that judicial determination. And here, I have the burden, and here's what I tell you. He never told me X. And the judge is sitting there going, that is not true. I know it's not true.
Well, he doesn't know it's not true.
He can't consider that?
That seems to
me to be the law going to a point where it doesn't make any sense.
No, I disagree, Your Honor. He cannot use his own knowledge to decide the case.
Well, what does he have to do then, recuse himself? Because I don't think there's any way for him to ignore it.
What if the plea judge was Judge Brennan, who was presiding on the Ananias litigation? Could he take notice of the fact that Waldbaum was involved in the Ananias litigation?
No, because it's not evidence. It's not evidence.
What if the Commonwealth had marked or offered into evidence a copy of the docket in the Ananias litigation showing Waldbaum's notice of appearance? Could the judge have taken notice of that?
If somehow it came in over objection and it was a court document, I think, based on, the law of what can be judicially noticed, he could, because it's an official document, but I would have objected to that coming in that scenario, Your Honor.
Anything? All right. Thank you very much for your argument.
Thank you, Your Honors.
We'll hear from the Commonwealth.
Sorry.
Good morning. May it please the court, Jennifer Cohen for the Commonwealth.
The Commonwealth argues that the defendant has not met her burden as to the second prong under Hallinan, as she's not shown a reasonable probability that she would not have pled guilty had she known of the government's egregious
I
misconduct.
know you just tried to pull the microphone closer, but could you
It
lean
didn't
in a
work.
little bit?
Is
Yeah.
the microphone
Thank you.
working? I'm really struggling to hear today.
I've been told that I speak quietly before, so. So, of course, the Commonwealth acknowledged in its brief, and I do acknowledge now, that there were some things that would have been better left out of this order.
Right, so where there's the substantial deference that we owe this judge as the plea judge as well as the motion judge, how can we feel confident that he exercised his discretion properly when he considered all of these impermissible factors?
Well,
Shouldn't there at least be a remand?
I have I've requested that that happen in the alternative to this court's affirming the motion for new trial, because I do understand that there are some problems here. But I do say that there is enough evidence, notwithstanding those improper considerations, to support the ultimate decision in this case. I do think that this stands on different footing to Hallinan, in that the breath test result was 0.10, whereas Hallinan was 0.24, I believe, and that also occurred at a sobriety checkpoint. So there is more information here regarding impaired driving. Of course, more is always better, but I do think that there is enough here to support the finding, the ultimate finding.
How does the fact that it was 1.0 here versus 2.4 or whatever in 0.24 in Hallinan weigh in the balance?
I suppose that it's not the crown jewel of evidence as the result was.
But it's still, I'm sorry, I may be confusing the per se violation with the impairment violation, but it's still over the
It is, Your
limit.
Honor. It is. But I think the difference with Hallinan is that, again, the stop occurred at a sobriety checkpoint, so there was no observation of the defendant's driving, and I think she did immediately admit to drinking 3 drinks, and then there was the breath test evidence, and I believe that's all the evidence that there was in that case. I think in addition to the evidence that we have here, there is also the circumstances
And
of
in that case, she admitted to having 3 drinks before she was pulled over.
Correct, and I think here the difference is
She
that
failed the FSTs.
right, and I think the difference here is that this defendant first denied drinking anything and then admitted to 1 drink and then to 2 drinks, and I think that goes to evidence of consciousness of guilt. Whereas the straight admission to 3 drinks, I don't
They're
think
not
is.
that far apart. I mean, and the
No.
court says as a matter of law, Hallinan gets a new trial, right? She
Yes.
admits to 3 drinks, she fails the FSTs. What's the difference here?
As Your Honor pointed out earlier, I think the circumstances of the pleas that were entered into are very different. I think the burden to this defendant was much less than the burden placed upon the defendant in Hallinan. In addition to losing her license for 2 years in Hallinan, I believe the defendant was required to attend weekly AA meetings and to be, or to submit to random alcohol screening, to enter a 14-day inpatient program, and to undergo a 24Q evaluation. Here, this was a 1-year quaff, 45-day loss of license, and I think
Court
she...
literally says in Hallinan's words to the effect of, she didn't get much out of her plea, right?
Yes.
What is the, and this is just my ignorance, but what is this hardship process? So she's been arraigned under an OUI. She automatically would, and she failed a breathalyzer. She'd automatically lose her license for how many days?
I believe 30 days.
And then how does she avoid having the license taken away? What's the hardship process?
So I'm not entirely sure of the hardship process, but it's my understanding that if she entered into the plea 2 days after her arrest, that kind of knocks out the 30 days of automatic license suspension she was subjected to upon failing the breath test. And then with the 45-day loss of license, and I'm not sure, Your Honor, how one applies for the hardship license, but it does appear to me that the judge placed significant weight upon that, and I do think that it allows the person to drive to work and kind of go about the necessary things that they have to do in order to get by.
Can I jump back to an issue that we raised with defense counsel, which is whether taking judicial notice of the defense counsel's involvement in all this other litigation was permissible? I think for the purpose of inferring that the defendant was informed of the many questions that could be raised about the breathalyzer test and yet pleaded. Is that kind of judicial notice permissible?
So, Your Honor, I would say that judicial notice in this circumstance would only be appropriate as to an adverse inference that can be made regarding the fact that no affidavit was provided by the defendant, and that was
an inference that the affidavit would not have been helpful, but not a specific, you don't think judicial notice of what he must have told the defendant would be permissible?
I don't think that's proper, Your Honor.
Okay. So that's another factor that he considered but shouldn't
How
have.
can he ignore that? I really don't understand that I don't like adopting a rule that objectively makes no sense. And it objectively makes no sense that the judge would have to ignore what he knows about what she's saying about someone who regularly appears in front of him. For purposes of evaluating the credibility of the affidavit itself.
And I think that
It's an odd thing that he evaluates, an affidavit's credibility. That's the motion for new trial process, right? But since he's charged with doing it.
I think it would be improper for the judge to take judicial notice of advice given to the defendant.
You're not saying he couldn't discredit her affidavit entirely.
No.
You're just saying he couldn't make an affirmative
Perhaps you went too
inference or
far.
conclusion about what defense counsel
I agree with
did to
that.
her.
I don't think he can infer what the lawyer said, but I think he can infer that what he's reading is incorrect.
I agree, Your Honor, and I think that that kind of goes to the fact that he has this awareness that I don't think he's required to ignore.
For what the lawyer knew?
I'm sorry.
Can the judge infer what the lawyer knew about the pending Ananias litigation and problems with the ALCA test?
Well, I would say that at least in the case law I've cited, it is clear that over 500 cases were consolidated at the time of this plea, so I think it is fair. I think it's fair to just take all of this information as an adverse inference towards not in favor of the defendant, and I suppose discrediting her affidavit and finding it very notable that no affidavit was provided by the defense in these circumstances.
So, looking at factor 3 of the test under Ferrara and Scott and I guess Hallinan now, whether the evidence of egregious government misconduct was cumulative of other evidence already in the defendant's possession. We can't infer that the defendant knew at the time of the plea that the breathalyzer test results would be inadmissible if challenged. We knew she may have known there was a possibility based on that sheet attached.
I agree, Your Honor. This information isn't cumulative.
Okay. So she does get some benefit from the, now
Yes.
she knows that that breath test would not have come in if challenged, and therefore we analyze her plea decision as if she had known that at the time. What would she have done? And has she shown a reasonable probability that she would have not accepted that plea agreement had she known?
And yes, I agree. It's not cumulative. I don't think that factors in the Commonwealth's favor here.
What do we do with the handheld breathalyzer, which I assume is not an ALCA test? So would that have come in at trial? And if it wouldn't have come in at trial, could the judge consider that as part of the defendant's calculus to plead? Even though it wouldn't be admissible, it might help her realize that she was really intoxicated?
I believe that the preliminary breath test is also inadmissible at trial, and so I don't think that it can go towards the calculus of whether or not she would enter into a plea. I think it makes the preliminary breath test more of an investigatory tool for the police rather than something evidentiary that can be used against the defendant at trial.
So I agree that should not have been considered here.
Anything further, John? All right, no. Seeing no further questions?
I'll rest my brief.
Thank you. All right, we will take a 15-minute morning break, and we'll be back to hear the remaining 3 cases after that.
All rise.
I'll follow you guys out.
seated.
All right, we are back for our final three cases. Our fourth case this morning is, I'm just turning to get the docket number here, 24P64, Department of Children and Families and Others versus the father. This is an impounded case. I'm sure you're all familiar. Let's not use any names or identifying information. And you'll be taking 15 minutes, as I understand it, and the appellees will be splitting their time evenly. Thank you. All right.
Thank you. Good morning, Your Honors. Joan Altamore representing the father in this case. Father appeals from a February 8th, 2023 decision of the Springfield Juvenile Court terminating his parental rights to his two children, L and K. The mother filed a stipulation at the beginning on the first day of trial and agreed to the termination of her parental rights, and therefore she is not a party to this case. At the very beginning, father states clearly that it was clearly erroneous for the judge in this case to find that father is an unfit parent and to terminate his parental rights. Parental unfitness is determined by...
I'm clear. Clearly erroneous, I thought, is the standard for challenging the underlying factual findings, but the ultimate findings, which are really conclusions of law, are that he's unfit, that his, unfitness will last for the foreseeable future, and that termination was in the best interest. So when you talk about clearly erroneous, are you attacking particular subsidiary factual findings?
Your Honor, we are attacking actually the case as a whole, the judge's findings. There are two factors to a termination case. The first factor is whether or not the father is unfit. We're stating that based on the record presented to him, based on the exhibits that were submitted to this that court, as well as father's testimony and the testimony of the ongoing social worker, that father should not have been found to be unfit.
Are you challenging particular numbered factual findings as clearly erroneous, or are you saying there wasn't clear and convincing evidence to support? I mean, you may be addressing both, but
correct.
Please be clear about which one you're going to address first.
Thank you, Your Honor. We are stating that there was not clear and convincing evidence. I know that one of my sister counsels...
Is that as a matter of law? So I'm trying to understand your argument just like Judge Sachs's. Is that argument accept the facts as found by the judge, including things like father is passive? And
right.
Do we accept those findings?
No, Your Honor. In fact...
Those are clearly erroneous.
Correct. And so that's where it is a combination, because when you look at unfitness, passivity is not unfitness. Unfitness is a grievous shortcoming by the parent in their capacity to be able to parent the child, looking at the parent's character, temperament, conduct, and capacity. This is a father who, when the first child was born, substance exposed due to the conduct of the mother. The second child was born substance exposed due to the conduct of the mother. The father does not have a substance abuse problem.
Well, the judge questions that. Was the judge clearly erroneous in questioning that?
Yes, Your Honor, because on what basis does the judge...
Father said, I don't abuse substances, and 5 days later he gets an OUI, which he pleads to.
Correct.
Okay, so why isn't that a basis for the judge to question whether or not he doesn't use substances?
Because fitness is also determined at the time of trial, and the father had a DUI, an OUI, in 2020, served
a year before.
In 2020, the trial was in 2023. And at that point in time, father had done all of his action plan tasks. And the department was actually in agreement that the father had done...
It wasn't one of his action plan tasks. I'm sorry, I'm trying to understand the nature of the argument. Wasn't one of his action plan tasks to perform a sort of a drug screen, I'm not sure exactly what, but an evaluation of whether he had substance abuse issues, and Father testified it was done, but never provided the result, and said that he disagreed with what his therapist had come out with when she did that.
I'm not familiar with that last part of the sentence, but what the action plan task was to do a substance abuse evaluation,
Right.
which was put in after the 2020 OUI. He did do it, then he was asked to do a second one and did do that as well. There is
But
testimony.
one of those was provided to DCF.
It was, a release was
And one, he
signed.
said, I disagree with the result. So how,
Okay, so the release was provided to the department, and the department is the entity that did not ask for the substance abuse evaluation, did not get it. He conducted that an evaluation twice. The second time with his therapist, one of the action plan tasks was, as is normal,
where
is to
will
do
I find the finding that the release was provided and DCF did not follow up?
I can follow up with your honors for what
Well, that's
point
all
in the
right. I'm gonna
text that is,
I'm going
because
to ask your opponent about it.
that's fine. And I will be happy to provide it too as well, because there was testimony from Father that stated, I signed a release with my therapist. The department had a release for the therapist, notwithstanding not just for the substance abuse evaluation, and the department regularly did communicate with his therapist. He actually had several therapists. One of the points for Father, I have a lot of clients. I am a regular practitioner in the juvenile court. We have a lot of clients who take time to find individual therapists. This client found an individual therapist, continues to this day in therapy. He is attending monthly therapy. He, in fact, had 3 different therapists, not through his own fault, but when the
Judge was
therapist left the
concerned.
program.
So are you challenging this finding? The judge was concerned because although he went to therapy, he was addressing his feelings vis-a-vis DCF and could not articulate other things that he was addressing. And this was a significant concern of the judge, despite going to therapy, he was not coming up with a plan for example, dealing with mother if he got the kids back. Are these findings clearly erroneous? What do we do with these findings?
Yes, Your Honor. And so in terms of, let's point out, mother signed a stipulation to terminate her parental rights. So in effect, she was no longer going to be the parent for these children. He could turn around and say to her, no, you don't have any visitation because actually there is no legal obligation. The judge, in clearly erroneously, inferred that because mother lived in the same area as father, in the same county as father, that it's likely, not absolute, but likely that mother would try and see the children.
But is that clear error for the judge to infer that?
Yes.
Or isn't it reasonable for the judge to say, do you have a plan for addressing that if it happens?
But the father had...
And the father had no plan.
The father actually had a plan. It is in the testimony, and I'd love to be able to point to the exact spot. Father did say that he would not allow, that father had addressed whether or not mother would come, and that he did not want mother to be involved with these children. But at what point, Your Honors, does the father have to have an absolute set plan for every day of these children's lives? He visited with the children regularly. The judge recognized that there was a significant bond between the father and the child. The department...
Doesn't he have to have a plan at least for how he's fundamentally going to take care of the children? Given that he works a regular shift, that his mother works a regular shift, that he needs a place for them to live, which the judge's findings are that they didn't have a place to live that was suitable. Is that clear error?
Yes, Your Honor, because he actually did have a place to live. If we just address the issue of housing, first off, father has had housing throughout the entirety of the case. Father, at the beginning...
It's not an issue of housing instability. It's an issue of whether he had suitable housing for himself and the children, right?
No, but it's an interpretation, and I would point out, Your Honor, actually, in Exhibit 8, which is a 51A filed at the beginning of the case, the Department of Children and Families actually did a visit to father's housing, which was at his mother's house at that point in time. They found that father had all of the necessary supplies for the child, L, who at that time was an infant, approximately under a month of age. And they approved father to live at his mother's house, the paternal grandmother's house, and agreed
but that's
to give him conditional custody.
2016 or whenever the child was born,
No, the child was born, I believe, in 2019.
2019. So that's 2019. But then, again, I read
Yes.
I read findings. This goes directly to what Judge Sachs was asking right off the top. I read findings of subsequent evaluations of the mother's house that say not acceptable.
Grandmother, paternal grandmother.
I'm sorry, paternal grandmother's house, because there's exposed electrical wiring. It's not clear that there's enough room for everybody. Is that clear error?
Your Honor, yes, it is, because basically, the judge is being speculative.
But then Dad moves out and in with a roommate who doesn't want DCF to come look at the house.
Correct. And that father said throughout the entirety of the case, if you tell me I'm going to get my child, then children, the two boys, I have an income, I have the sufficient means in order to get my own housing. And DCF and then the court would not give a date. So telling father...
He wasn't even saying, if you tell me I will have custody returned to me. He was saying, as long as the goal has been changed to adoption from reunification, why should I, in essence, why should I look for housing that's suitable for the children while you're not, when you, DCF, are not even pursuing reunification?
And that comes to the part of the case, Your Honors, that basically the judge is saying that father's failure to demonstrate he's prepared to meet all of the children's the judge said that the barrier is father's failure to demonstrate that he's prepared to meet all the children's needs on a constant basis. And yet what the standard is supposed to be is father doing his action plan tasks. Is he doing what is necessary, what the department has determined is necessary, so that he can meet these children's needs? They wanted him to do therapy. He did therapy. He continues in therapy. They wanted him to do substance evaluation. He did not just one, but he did two. They wanted him to visit consistently with the children. There is no evidence anywhere in the record that father missed a visit or that the department either terminated or suspended a visit. In fact, the visits moved from in the office at the Department of Children and Families into the community for father. There is ample evidence from the ongoing social worker that her observation of father's conduct with the children during the course of these visits was appropriate, that he knew how to set barriers with them, he interacted with him, they greeted him with hugs and affection.
So there was a finding that the social worker had said, well, she did say, and the judge found, that occasionally at visits, he lost track of whether the children were being kept safe or whether their needs were being met, and occasionally she had to redirect him onto that issue.
And, Your Honors, that, during the preparation for this oral argument, I was talking with the CPCS panel and said, when somebody gives birth to a child and the parents are given this child from the hospital in most cases, and they're allowed to walk out the door without anybody telling you what you have to do. You have to learn as you are a parent, as this child grows. And so at what point in time is it wrong for the social worker to give advice to a parent?
We know what the safety issue was? I mean, were they about to run into traffic, or might they have risked us getting a skinned knee?
And that's part of the point, Your Honors, that in the course of the testimony, there is no evidence to show why the social worker had to redirect, not even redirect.
So we don't know how serious the issues were on which she had to direct him to pay attention.
And I would point out, throughout the entirety of the case, during the entirety of the visits, there was no 51A filed such that they felt that the parent had endangered the child. In fact, what is consistent through this case is the recognition by the department in both the family assessments, which there are approximately, I believe, maybe even 10 family assessments in the exhibits, in the foster care reviews, which occur every 6 months.
Your time is limited, and I have a couple questions, so.
Thank you. Okay.
Is your point about the number of strengths, 13 strengths and 10 not applicables and 2 areas of need? Is that the point you were about to make?
Yes, Your Honor. That the department recognized that that father had 13 strengths, 10 were not applicable, and only 2. The department consistently recognized father's strengths.
Okay. So the judge was concerned that if custody were returned to the father, he wouldn't be able to keep the mother at a distance, in essence. I want to ask, the mother did stipulate to termination, but that was accompanied by a stipulation as to post-termination and post-adoption visitation. If the custody were returned to the father, those stipulations would not really have any effect. Is that correct?
No, that's incorrect, Your Honor. In my reading of it, that mothers, and my time is, but to answer your question.
We don't have the stipulations in the record, so we don't know.
Correct. We don't have a stipulation in the record, but from a regular practice, if mother's rights are terminated, they are terminated, whether or not father gets custody.
But if they were terminated and she had court-ordered visitation, then there might not be an issue of whether she's going to badger dad to allow her to spend more time with the kids. But if she no longer has that court-protected right to visit them because custody's been returned to the dad rather than being given to the DCF or to the post-adoptive parents, then may she be badgering dad?
But,
and
Your
is
Honor,
that
I
more
would
of a
point
concern?
out
That's
this.
more a factual question, and we don't have the stipulation, but...
We don't have the stipulation, but I will point out, usually when a care and protection case reaches a conclusion and you have, if the case is closed and there's a dismissal, the next step, the recourse is to go to probate court. With mother having her parental rights terminated, she has no recourse in probate court to demand visitation. So any visitation would have to be at father's willingness, because she has no legal recourse.
So it would depend basically on whether he can be firm enough to say, no, you're not getting near the kids, or something like that.
Correct.
All right.
And
she no longer has any other guaranteed access to the kids.
correct.
Okay.
I have a question. During the dad's testimony, the judge asked about what would happen if the custody was returned to the dad and pointed out that I think the younger child, who's 4, has been with the foster parents since he went home from the hospital.
Correct.
And the dad didn't seem to understand what the judge was talking about when she said, what special needs would the children have if they were returned? Isn't that something the judge could consider in his demeanor as showing his unfitness?
So first off, the children had no demonstrated special needs. They had been tested at an early age. There's no documented special needs. In terms of that particular question, my recollection of father's response was that this had been asked of him previously by the department. These children have a bond with the foster parents, who are the pre-adoptive parents, whichever way you wish to characterize them. And they said to father, if we were to give you back the children, what would you do? And his testimony was that I say no. Then the testimony continued, and he said, I thought about that answer. I went back and I reflected, and I contacted the department a week later.
I just want to let you know that the time is running, and please finish your sentence.
That I realize that my children do have this bond, and so I do want to make arrangements to not have them lose that bond. So I will make arrangements for there to be regular visitation, time on the weekends, and even overnight visitation. So he's opening his heart to understand what his children want and need.
All right.
Thank you.
We have to have one more question. Another line of questioning.
Along the lines of what the father can and can't be held responsible for. Both the children were born with drugs in them. And that's neglect by the mother.
Correct.
Why isn't it also chargeable to the father, who was apparently present for both births?
Correct. But that's the beginning of a care and protection case. The point of a care and protection case is to ensure that the children are no longer subject to abuse or neglect. And to get to that point, corrections have to be made, actions have to be taken, and things have to be learned. And that's why there is the creation of an action
Saying
plan.
it's stale or it's dated. And that's why you went to services. But then you have the judges finding that the services haven't changed him sufficiently.
That's the judge's interpretation, and yet the department recognized that father had actually grown.
That's clear error. That finding that the services had not significantly affected father is clear error in your view, based
Yes.
on the testimony of the social worker.
Yes. At what point does a parent become fit? It's an amorphous, there's no set bar. The bar
All right,
here.
we need to finish up.
Thank you.
Thank you. All right, we'll hear from the department. And at some point, maybe you can address the social worker's couple of lines of testimony that she had to intervene on multiple occasions when there were safety concerns or when a child's needs were not being met. But we know nothing about the gravity of any of those concerns. How can that be clear and convincing evidence of his unfitness?
Yes, Your Honor. Good morning, Your Honors. Claire Gilchrist on behalf of the Department of Children and Families. So the judge credited the social worker's testimony, and father in part corroborated that testimony. So even though
Corroboration didn't give any more detail, right? Yeah, sometimes I had to, they would interrupt me and get me to, pay attention or something like that.
well, he acknowledged that the social worker had to step in to prompt him to manage the children. That's what he acknowledged. And
That's clear and convincing evidence of unfitness?
no, Your Honors, that was one consideration that the judge had among
The
many.
judge put a lot of weight on that, it seems to me.
She did, because she looked at how young the children were. They were 2 years old and 3 years old. They need constant supervision for their safety. They're energetic toddlers.
But we don't know how serious the concerns were. That's my difficulty with her very substantial reliance on that one bit of testimony. If this were, the kids were about to run into traffic and I needed to tell Dad to pull them back, that would be one thing. But if it's the kids were running around and one of them might have tripped and gotten a skinned knee and I cautioned Dad, that would be totally another. And in fact, there was evidence, I believe the foster parents reported, that one of the children was tripping more than they expected, and there was some question of whether that should be followed up on medically. So without knowledge of how serious these concerns were, I mean, he's not attending to the kids' needs. Is this like they have a 104-degree fever and he's not taking them to the doctor? Or is this one of them has a runny nose and he's not wiping their nose soon enough? We just don't know.
Well, Your Honor, what we do know is that the social worker testified that she tried not to intervene. She tried to only intervene when it was a safety issue or when needs were being unmet. So we do know from that there is some context there, that she's not just intervening for, a father's not redirecting the child.
It's the department's burden. It's the department's burden here. So I don't know that we necessarily draw that inference in favor of the department when the burden is clear and convincing evidence. I mean,
Is it
I'm not
an
saying the
inference when
judge's
she's
finding that the social worker said that is erroneous, but I'm saying how much weight can that get in the clear and convincing analysis without knowing what it's about?
Well, Your Honor, the social worker testifying on what circumstances she intervened, that's not an inference, that's her actual statement of
Yeah, she
when
tried
she
not to.
Yeah, she tried
Could
to let
be
him just
overbearing.
parent.
I'm
sorry?
We don't know. What I think Judge Sachs is getting at is from what is in evidence, we don't know whether she's just being overbearing and commenting that she had to intervene from time to time because Dad was willing to let the kids roughhouse a little bit more than she might be willing to let them roughhouse, or whether it was something truly serious.
Well,
I think that
is the issue that the social worker, she was asked, and how does Dad react? And she says he doesn't usually acknowledge it. So whether or not the social worker was saying the kid has a runny nose or the kid has 105 fever, either way, if the dad doesn't acknowledge it, isn't that the passivity problem?
Yes, Your Honor, there's a passivity problem there, and also Dad's own words where he's not saying the social worker, did step in. He's acknowledging that she did have to step in at times. So I think that's an important distinction there. And certainly, the judge was taking the word, the plain meaning of the word safe.
Dad's actual testimony, the father's actual testimony in front of you?
I'm sorry, Your Honor?
Do you have the actual, do you have the actual testimony in front of you? Can you read it? If you don't worry, I'll look it up.
I believe I do. I took it down. So that it was page 58 of the transcript, where when he was asked if the social worker has ever had to redirect him on his interaction with the children, he said she has.
Okay, but we still don't know what it was. I wanted to
Right,
ask
Your
you...
Honor, we don't have any further detail.
Okay.
But as far as the...
I want to ask you about another point made by the father in his brief, that on his most recent assessment, DCF rated him as having 13 strengths, 10 factors that weren't applicable, only 2 areas of need, and those were only sometimes. You say in your brief, the judge didn't deal with that at all, that I can see. You say in your brief that this was based on a period when the mom and the dad were having joint visits, and the mom was doing most of the parenting. But I looked at the assessment of the mom from that same document, the same period in May through November of 22, and she gets only 3 strengths, 18 not applicables, 3 needs, and 3 high needs. So your suggested explanation that she was doing most of the parenting so it was easy for him to look good doesn't seem to be borne out by the assessment itself. So I don't see, where there's that very positive assessment of the father, again, it raised the question about whether the evidence is clear and convincing.
Your Honor, so to your first point, the judge does acknowledge that the department has found some strengths in father's parenting. She has a finding I think she has multiple findings, in fact, concerning that.
I saw she said there was some inconsistent improvement, tracking what the social worker had said.
So I think if we look at its finding number 27, which is page 63 of the record appendix, the department even indicated that father has shown signs of improvement in areas of parenting. So that would be the evaluation there when we're talking about different areas of parenting. In terms of, whether mother was present for all those visits, father testified that
So that it's that one sentence that you just read that is how the judge acknowledges apparently the father's very favorable scores on this assessment of parenting abilities.
Well, the judge is weighing the evidence, and there's evidence against what this assessment says, which is the social worker's direct observation of father during visits versus a document that was prepared by another social worker 8 months before trial at a time when
evidence from her direct observation during visits.
I'm just going to stop you 1 sec and ask maybe if we can stop the clock. We have a noise, like an electronic noise somewhere. Not sure if it's in the courtroom or outside, but.
I apologize, Your Honor.
No problem. Thank you.
I was asking
Where
a
were we?
question. Well, the question I was asking, because you commented, I think you were distinguishing between the, what appears to be a fairly favorable evaluation of the father on strengths and weaknesses, and you were saying, but there was evidence from a social worker who was observing father when he was at the visits. And what evidence is there from the observation that he was doing poorly, other than this, he had to be redirected once in a while?
So that is the evidence, Your Honor,
But
that
the
the
pro-
judge
we- so
considered.
that's what we
She
just
also
went
considered
through.
other aspects of father's parenting that were lacking. So it wasn't just the visit, but also his inability to plan for the children's care. And that was very obvious during his testimony at trial, that everything was
faulted
going
quite
to
a
be
bit
solved
for-
in the future.
He was faulted quite a bit for suggesting that the kids could live with a paternal grandmother, and the judge said she had a finding 26, there were exposed electrical wires in a period of no heat or hot water. Finding 25, there was no heat. At another point, electrical work was in process and creating a safety issue in the home. Where is the evidence of any problem with heat or electrical issues? I couldn't find it anywhere. And I just wondered whether the judge was paying close attention to the evidence.
So that, Your Honor, was the testimony of, there was testimony both from the adoption social worker and the paternal grandmother.
A hot water issue that was fixed,
Around-
evidently.
Correct.
Hot water,
And
right.
the electrical was, here, let me find that finding. I believe it was the adoption worker's testimony, and there was also, I want to say there was documentary evidence, but and Your Honor, I can find that in the record and
If you
provide a
could
letter
let
to
us
the
know
court.
where that evidence is.
Yes, I can, Your Honor, I can do that. Certainly follow up on that. Your Honor, I think the key here is that father, after nearly 4 years at trial, simply had shown that he simply did not have the ability to plan to meet the needs of the children or even understand what those needs are. Everything was going to be resolved in the future. How he was going to interact with mother in the future and respond to her approaching him, he was going to figure that out later. He was going to figure out daycare later. And he did not acknowledge that the children would likely have needs being removed from for child 2, the only real, family that the child had known. And so these were very present on the judge's mind, and also his risky behavior, and his lack of acknowledgement that behavior was risky in terms of, the DUI and, blaming essentially seeming to blame the police for having that, as well as his continuing to blame mother for what happened at the hospital, even, again, almost 4 years later at trial.
If we were to conclude, hypothetically, that there was not clear and convincing evidence here, what would the appropriate disposition of the appeal be?
Well, certainly, the appropriate disposition would not be to return custody to father today. It would be a remand to the trial court. It's been over a year, almost going to be 2 years in January.
So
there's a lot.
What happens next in the trial court, I guess is another way of asking.
So if this case were remanded to the trial court, then the court could hear evidence
Would the original care and protection petitions remain alive and temporary custody remain with the department?
Temporary custody would
unless and until the judge orders otherwise? And the judge takes more evidence, or?
Correct, that's correct, Your Honor. It would be temporary custody of the department, and there would be a new hearing where the judge would hear evidence, and of course, hear evidence on what's been going on the past 2 years with father.
All right. Thank you.
Thank you.
All right, we'll hear from counsel for the children.
May it please the court, I'm Sherry Krasner on behalf of the children. We're asking the court to promptly affirm the judgment finding father unfit and dispensing with his need for consent to the adoption of the 2 children by their foster parents. And I want to acknowledge the presence of the foster parents here in the courtroom today. answer some of the questions that the panel has raised, with respect to the substance abuse evaluation, that's in finding 15, where it speaks of the department not having ever received the substance abuse evaluation, and with respect to the grandmother's home, the condition of the grandmother's home, that's in findings 25 and 26, and the judge cites to which testimony and exhibits she looked at in making those findings. Also, with respect to the issue of the visits, although we don't know specifically what concerns the social worker may have had, we do know this was a case that was came in 2019, trial was in 2023. Father was having regular visits. He came to the visits. He came prepared to visits, but visits never moved to unsupervised. So I think, although we don't know specifically what the social worker was observing, I think a reasonable inference can be drawn from the fact that they never moved to unsupervised.
But the social worker did acknowledge that father's performance as a parent, if you will, was improving. She said, albeit inconsistently. And one of the questions before us is whether there was clear and convincing evidence that this unfitness was going to last indefinitely to a near certitude.
And I think in the context of having regular visits for 1 hour in a contained situation, that you can't move past that is certainly, parenting is not 1 hour once a week.
Is there evidence that DCF considered unsupervised visitation but didn't offer it because they were too concerned about what would happen during the visits?
I think that there's no direct testimony about
It's an
that,
inference.
but I think the inference is very clear. If you
Is an inference like that, does that amount to clear and convincing evidence?
that's not the only issue in the case, so I think I don't have to answer that question directly in terms of whether it is. If that was the only issue.
Is it a permissible inference that there were substantial safety and concerns about him not meeting the kids' safety needs and other needs in visits?
Certainly, the totality of the evidence. This was a father who could have attended the medical appointments of the children.
And DCF said that they didn't invite him. They said they didn't invite him to the early intervention sessions for the younger child because they'd changed the goal to adoption, and it really didn't occur to them to involve him.
But for he could have attended, he did attend some appointments for the older child, but then was not really able to articulate what happened in those sessions.
Okay, but when the judge talks about blaming his passivity, and yet the department says, well, we changed the goal to adoption anyway, so we didn't invite him, and then that becomes a black mark against him for not attending when the department didn't even think to let him know?
Yeah, I would say to an extent it does, because you need to be proactive as a parent. You need to show that I'm going to take the initiative. I'm going to find out what are my child's needs. And so I would suggest that, yes, in this case, and that passivity, I think the judge, I mean, she made lots of findings. She made 31 very comprehensive findings. But the most trenchant observation was this father's passivity, and that everything was everybody else's fault. And please remember, Your Honors, too, this was not a young parent. This was a 40-year-old. He was 40 years old, or a few months short of 40 years old when the first child was born, 43 years old at the time of trial. This was a grown-up. This was a mature adult.
I didn't see any mention of evidence that he had other children?
No.
In the past?
There's not. And well, also, he was incarcerated. You have to remember, he was incarcerated for a period of 7 years. I think the charge was 5 to 7. He got out. It's about 6 years. But it was this, if mother was using drugs, it didn't happen around him, and so it was out of his control. When mother arrived at the hospital, when father was at the ER, and
yeah,
not my fault.
He did take some responsibility for that incident, which happened, 4 years before trial?
Right. But it happened after he had an infant in his custody for a couple of weeks. It's unclear who that
Other than-
infant was with when he scaled the fence. I mean,
Other than that incident, what did the father do that actually caused harm to the children here?
well, the children were never in his care. The younger child went directly from the hospital to the
All right,
foster.
so you're saying none, in essence?
Well, he didn't have the opportunity.
Okay,
I mean,
all right. So what
but-
did he do that would put them at real risk of abuse or neglect?
Well,
We're
the-
we're really talking about neglect here, right? Not abuse?
Correct. I mean, but what the judge said was that it was just that he was so divorced from their needs, from putting himself in their shoes, from doing the things that a parent has to do. And I want to go back to when Justice Grant asked the question about the needs of the children being removed from the only home that they have ever known. And it's at page 109 of the transcript. And the judge zeroed in on that. The judge was the one who asked the question about, well, how will you address the needs of these children if they are removed from the only home that they've ever known? And he said, well, I don't think they'll have any special needs. And that inability to put yourself in the shoes of your child, to look at the world from their perspective.
Okay. But then he comes back and says, you know, I've thought about it. I think that they will want to have and maybe will benefit from ongoing contact with the pre-adoptive parents.
And
I'm willing to consider that.
Respectfully, Your Honor, I think you have that backwards. I think he talked about those things he would do before the judge asked the question. So he agreed, okay, I'll let them.
Was it an issue of terminology that he thought the needs they would have as a result of being separated from them were the special needs, like a need for, you know, a particular, or an IEP, or?
Respectfully, I don't think this father, through the rest of his testimony, showed that sort of sophistication. I mean, the judge was asking about, these children aren't going to be in the home, theoretically, are not going to be in the home in which they have lived their entire lives with the people that they call mom and dad. And he's, well, there's not much to it.
The judge invoked Factor 7, which calls for which depends on there being a likelihood of serious psychological harm. The judge didn't really address that with any specificity. What basis does the judge have for saying that there would be a likelihood of serious psychological harm if they were removed?
I think to remove children from the only home in which they have ever lived, so that I certainly think you can infer that bonding with those parents has occurred.
Yes.
And it was not the only factor. She found 7 of the mandatory.
But I'm focused on this particular one at the moment.
And the case, well, but the case law does not require her to make those specific findings unless that is the only factor upon which she is hanging her determination of the statutory factors.
Factor.
And that's adoption of Daniel and adoption of Larry. So that was just but one of the factors upon which.
I have one question. You pointed us to finding 15, which has to do with the substance abuse evaluations. Your opponent says, oh, he gave a release, but the department never followed up. There's no mention of that in finding 15. What do you say to what your opponent says on that?
I mean, it says that the department didn't receive the report.
So that becomes his fault.
If he's looking to have the burden of proof at trial is always on the DCF. But again, that idea that father is just a passive observer of this isn't the way these cases are supposed to be handled. He should. Do you have that report? And he didn't follow through on that. And the panel has no other questions. I'll rest in my brief. Thank you very much.
Thank you very much. Thanks to all of you. Very challenging and difficult case. All right, our next case is 23P1183, Zurich American Insurance versus LM Heavy Civil Construction. Mr. Tyne.
Good afternoon, Your Honors. Andrew Tyne for the defendant appellant LM Heavy Civil Construction LLC. The underlying matter concerns a surety case, surety's claims against a contractor, my client, for alleged default on surety bonds. My client responded to the surety's complaint, hired counsel Todd and Weld. Todd and Weld defended this matter, responding to every pleading, up until the point that they made a decision to withdraw, which was communicated to my client as being final as of November 20th, 2022.
So there wasn't, as I read your papers, there wasn't a failure to plead?
Correct, Your Honor. There was not a failure to plead.
Was there a failure to otherwise defend?
I don't believe so, Your Honor. From the case law that's cited in my papers, I don't believe that a failure to have counsel equates to a failure to not defend or to not respond to pleadings.
So in essence, you're saying 55A didn't apply?
Correct, Your Honor.
You make that argument below?
I didn't hear, Your Honor.
Did you make the argument?
I did, Your Honor.
55A was not met by the circumstances here in the trial court?
Yes, Your Honor.
Where did you make it? Because I couldn't find it. I saw references to not following 9A or following 9C. I did not see that argument made to the trial court, and I think the first time that I saw the argument was not even in your principal brief to this court, but in your reply brief.
See, I believe it was in my motion to remove the default, Your Honor, because
well, there are three of those. Can you tell me which one?
I think all of them, Your Honor, because raising 9A and 9C, the argument was that it had to be a motion to remove the default as opposed to a request under 55A. So therefore, that argument is really one and the same, that it had to be a motion, not a request.
Respectfully, counsel, I'm not sure I agree with that. Saying, hey, they didn't follow 9A, they had to follow this process where they had to send it to me first. Of course, it's not you because there's no lawyer at the time. Instead of saying 55A doesn't apply. The reason it doesn't apply is because you have to meet this language and you can't meet it in these circumstances. That argument is not in the pleadings, is it? Not in the pleadings below.
I really, respectfully, Your Honor, I thought it was because I believe that, again, Rule 9A, my argument was that you have to file a motion. And the request, it is a request under 55A, so therefore they didn't follow 55A, and my point was 55A didn't apply.
Okay.
So the
then let's talk about how do you don't have a lawyer. You're a corporation, you don't have a lawyer, and you've been advised for over 60 days that you got to find a lawyer. How is it that that's not a failure to otherwise defend? If the plaintiff wants to move for summary judgment, what are they going to do?
I think Rule 9A has to be filed whether or not the corporation has.
How can they follow Rule 9A? They have no one to serve the motion on. You have no one representing you.
It's no different than a pro se defendant, Your Honor. I understand a corporation can't represent itself.
It's different than a pro se defendant. Isn't it fundamentally different than a pro se defendant, which is why your client was advised on February 6th, you're going to be defaulted if you don't get a lawyer?
My client was advised that we're at risk of default, Your Honor, and the proper procedure would have been for the plaintiff to file a motion for default, serve it upon the unrepresented entity. The unrepresented entity would have received notice. In fact, I believe they should have called the unrepresented entity.
What's the difference between that and what they did do? Didn't they serve the unrepresented entity with their request for a default?
Because it shortens the time frame, Your Honor. There's an obligation to call the unrepresented entity.
Why do we care about how long it takes? You've already had over 60 days, haven't you?
Because finding counsel in a complex case with over $30 million in dispute involving various legal matters, it's difficult to get people to enter an appearance, and the corporation, time was important. Time was important to this corporation to be able to identify and find counsel, and by rushing the process, they were denied that opportunity.
You know, all right, I understand what you're saying.
Yes, Your Honor.
I practiced in this area, not this specific area, but I always thought that the rules of civil procedure say you have to answer a complaint within 20 days. The notion that you can't find a lawyer for 90 days is, to me, quite extraordinary, especially when someone's saying, you owe me $30 million, and your answer is to say, can't find a lawyer, and therefore we're going to just stay everything with respect to this $30 million of yours that I haven't given you back.
Right, so I wasn't involved in the process of trying to find a lawyer.
I'm not challenging you and what you did. You came in March, I think. I understand that, but the argument strikes me as rather extraordinary. The first thing I'd start with is the rules say you have to answer a complaint within 20 days.
Understood, and a case that is brand new is actually easier to find counsel than to find a case that has a lot of baggage, like this did, Your Honor.
But what happened is your client didn't pay its lawyer, so it lost its lawyer.
I think that may have been one of the issues, Your Honor, but there was a secondary issue which Todd and Weld had a conflict, which created a problem for this client from the start, which was really not disclosed to this client. They represented separately the principal of the corporation, and the principal really should have been deposed in relation to the defenses that were being asserted in this case. So this created a situation where Todd and Weld really wasn't properly defending this client, the corporation, because
that sounds like a malpractice case, not a reason why this default should be removed.
Well, I think that goes to the fault of whether it's the counsel or the corporation as to why they were defaulted in the first place, which I think counsel led the corporation along in representing them for a period of time where they shouldn't have, and therefore put them in a position where they were ultimately defaulted, Your Honor. And I think that goes to the blame, is one of the factors in the Berube cases, Your Honor. As to the other factors, Your Honor, this obviously is a large amount of money. It's more than $30 million. There would be no prejudice to the plaintiff in providing additional time to identify and retain counsel, or removing the default so new counsel could appear.
It takes longer for them to get paid. Is that prejudice?
There was an attachment in place, Your Honor, as to basically all of the known assets of my clients, so they were protected.
That attachment going to be sufficient to cover a $30 million judgment?
There was nothing beyond that, Your Honor. The attachment was the only security that I understood existed.
Is the attachment going to be sufficient to cover a significant portion of a $30 million judgment?
I don't think it's a significant portion. I think it was around $1 million or less, Your Honor, so I don't think it's a significant portion, Your Honor.
So why isn't there prejudice from the fact that it's taking longer to move along a case where someone needs to get paid?
I don't think prejudice is 30, 60, even 90 days in a case, Your Honor, where there's security in place to the full extent available of the assets of the corporation. I think the plaintiff, again, rushing this along, put my client in a more difficult position than it already was in trying to retain counsel because of the complexity of this case. And, cases of this nature, which are older and complex, it's difficult to get attorneys to appear in them. So it's not the same as getting an attorney up front in a case where there's a short answer period. As to the other factors, Your Honor, I did file a motion to amend the complaint. I provided detailed factual allegations in that first amended complaint with documents attached thereto to support those allegations, mainly arguing that the surety was asserting control over this corporation, which was inappropriate. They were using their leverage, their financial leverage, over the employees of the corporation and enticing them to act in the best interest of the surety as opposed to the principal, and not protecting the principal as a result. And I think those counterclaims, as alleged, have validity. And the problem with this case in terms of not being able to submit an affidavit is that the principals, as alleged in the counterclaim, are really part of the wrongful conduct with the surety working together because they had an interest which was different than the corporation. And as a result, there's no way my client could submit affidavits, Your Honor.
You're making the argument about whether or not you had reasonable defenses shown, right?
Yes, Your Honor.
I'm reading now from your last motion for relief from default, which on this subject of whether you raised the question of compliance with 55A. This is what it says. Plaintiffs did not serve the request seeking default pursuant to Rule 9A as a motion. which was appropriate given LMH had appeared, answered, and otherwise defended, but simply lacked counsel at that point in time. Plaintiff also made no effort to satisfy Rule 9C. So is it this sentence that I just read to you is the one that you think alerts the court to the applicability of 55A under the circumstances?
I think so, Your Honor, because they had to serve it as a motion and not as a request for default.
Even if they'd served it as a motion, that would have gotten you until late February, I think.
It would have extended the time frame, yes, Your Honor.
10 or 13 days. But counsel, counsel didn't appear until mid to late March. So did the failure to follow Rule 9A actually result in prejudice?
I mean, I can't say what the client would have done in hindsight, Your Honor, if they received a phone call pursuant to Rule 9C, if they received papers which they understood they had to respond to under Rule 9A, whether they would have consulted with other people and acted more quickly. Instead, they were put on their back foot. They received the papers. They did file an opposition, I believe, which was docketed after the court entered default, but still would have been timely under 9A.
Was the corporation provided with a copy of the request?
Yes, Your Honor. They were served with a copy of the request.
Okay.
That is my understanding.
So the only problem then is not a failure of service, because there's no lawyer at the time, but a failure to, in your view, to file a motion. And what would the motion have said? Motion for default?
Should have been a motion for entry of default for failure to have counsel of record, something of that nature, Your Honor. And there should have been a Rule 9C call.
Wouldn't have been a motion under Rule 55A?
I don't, 55A is to be directed to the clerk, Your Honor. It's a request for default for failure to plead.
The order to enter the default was made by the judge here. That's his signature.
Yes.
So wherever a motion, wherever a request under 55A should be directed, in fact, it was ruled on by the judge here.
Understood, and I believe
What
it was...
authority is there to grant the motion for default other than Rule 55?
I believe it's Rule 55B as opposed to Rule 55A, Your Honor. And I believe it should have been a motion. And I believe when it wasn't served under Rule 9A, the trial judge should have rejected it for failure to comply with Rule 9A.
Difference between 55A and 55B, I'm sorry, I wish I had the rule in front of me, but I don't.
55B is judgment. 55A is just the default. So he didn't enter judgment before there was a motion for damages and a hearing and so forth.
But under 55A, a request can only be directed to the clerk under certain circumstances for entry of default, whereas it's unclear in that rule what procedure is to be followed where there's a lack of counsel, although I believe the case law makes it clear that my client didn't fail to defend or fail to respond to pleadings, and
That's
therefore...
true, then there's no provision in the rules to allow you to file a motion for default. So I'm trying to understand how you want us to construe the rules.
If the clerk cannot enter the default, then a motion needs to be filed. And
Where
there's
does
only
it say
certain
that? Where does it say that?
It's in Rule 55A. It says under what circumstances a request can be made to the clerk. And then there's case law construing it, which is in my brief, which indicates it's only under circumstances where there's a failure to plead or defend.
So where Rule 55B2 says, in all other cases, the party entitled to a judgment by default shall apply to the court, therefore, are you saying that because this was a request, it should have been a motion, and that's what apply means?
I think it should have been a motion because a request for default can only be utilized where a party fails to respond to a pleading.
When you say there are cases that help you on this question of otherwise defend, I saw that you cited them, but remind me, are there Massachusetts cases on that subject? What are we saying?
I think you cited the Curley case from Massachusetts.
I cited Nickerson v. Flynn Morris. That's for Rule 9A. As to
Curley Customs says the words otherwise defend refer to filings such as a motion to dismiss that defer the requirement to plead to the claim for relief.
yes, Your Honor.
If a party has counsel, a defendant has counsel, but then loses counsel for whatever reason and doesn't have counsel for some extended period of time, what is the plaintiff's remedy? Is it a default? Is it the conducting of a trial to determine liability as well as damages? What is the court supposed to do in that situation?
I think the plaintiff should have filed a motion for entry of default for failure to...
Well, but you're saying that this was not a proper situation for a default because you hadn't failed to plead or otherwise defend.
No,
So
no.
if 55A isn't applicable, what is?
I was saying it's not a proper situation for a request because a request avoids 9A and Rule 9C.
So if your argument is that if this had been done as a motion, it would have been permissible?
Procedurally, yes, Your Honor. And then the question would have been, should the default have been removed?
You cite no case and no rule provision that is consistent with that position, right? You can't cite us to a provision of the rules unless it's the one that Judge Grant just read, which doesn't say you need to file a motion, or a case that says, okay, when you don't have counsel, the way you get a default is.
There's not a case that I could find that speaks to when you don't have counsel, this is how you get a default, Your Honor. What I found is that to obtain a default, if it can't be directed to the clerk, it needs to be by motion, was my understanding from the case law that I read. And you can only direct it to the clerk pursuant to a request and avoid 9A and 9C.
Can we just leave us, avoid 9A and 9C always bugs me because I'm like, who am I going to serve? I got nobody to serve. How can I do a conference under 9C? I can't call the other side because they don't have a lawyer.
I think there's still an obligation to comply with Rule 9A, Your Honor.
Okay. All right.
Thank you.
Seeing no further questions?
Thank you.
We'll leave it there. Thank you.
Good afternoon. May it please the court, my name is Linda Morkin. With me is Dennis Kavanaugh. We're attorneys with Robinson and Cole, and we represent the plaintiffs' appellees, the sureties.
Wouldn't it have been a lot better if you filed this as a motion rather than a request?
I don't think so, Judge Englander, because Rule 55A is the appropriate mechanism to enter a default for failure to appear. And I would refer this...
Does it say failure to appear?
Well, what it says is that
Failure to plead or otherwise defend are the substantive grounds.
Correct. And the reporter's notes indicates that a failure to file anything at all is under 55A.
Okay, but there wasn't a failure to file anything at all. They answered, I think they had an original counterclaim.
They did, but at this point, in fact, it was the warning to LMH by the court when it allowed prior counsel to withdraw that you are at risk of default.
Okay,
is a default proper under 55A? Was this situation of not having counsel for some period a failure to plead or otherwise defend?
Otherwise defend.
And there's no case that says that.
Two points, Judge Englander. First, the National Grange versus Walsh case, which we cite in our brief, is a case where it was a 55A default followed by a default judgment under 55B. That is the way this is supposed to work.
What's the site?
It's at page 24 to 25 in our brief.
And what were the facts there that led to the default?
It was a failure to appear. And then a default judgment.
A failure to appear before, and was anything filed? Was any pleading filed or motion to dismiss or other?
That I'm not familiar with that detail of the case.
That's kind of a key distinction, isn't it?
Well,
the Curley case does say the words otherwise defend refer to filings such as a motion to dismiss that defer the requirement to plead.
True, but...
So if you don't plead and you don't file a motion that defers the requirement to plead, like a motion to dismiss, if you do either of those things, then it doesn't seem like 55A is applicable.
Curley is in a posit because it's not a failure to appear case. It is a true failure to defend case, a failure to respond to a motion. That's why I cite you in the direction of the National Grange case, because that is one where this court
approved of a default judgment following a default for the failure to have an appearance on file, whether it was an initial or a substitute. I don't know that this court would want to make any differentiation on that basis. The idea that I think the justices appreciate.
No answer or appearance was filed on behalf of the defendant. I'm reading now from National Granger.
Yes.
Well, no answer is a failure to plead.
Well, but there wouldn't.
In the plain language.
Could not be an answer unless there's an appearance, which ties.
Yes, there could. In our case, there's an answer. There's actually discovery. There's all kinds of stuff that happens. The question, I mean, look, the National Granger doesn't answer the question, it seems to me. It answers the obvious point that if you don't answer at the beginning of a case, then 55A is appropriate. Your opponent says 55A is inappropriate in the context where the case has been going, you're a corporation, and now you don't have a lawyer. Which leads to the obvious question, well, what do you do?
Absolutely, and that's why I believe 55A is the answer, that it doesn't apply just to a preliminary appearance. Certainly nothing has been cited to the court that is some limitation. And as you point.
But then if 55A applies in cases beyond the answer, why do we have the language in 55B2, in all other cases, the party entitled to a judgment by default shall apply to the court therefore? That language seems to be precisely to deal with a situation like this.
No, Justice Grant, I believe that reflects the second step, which is the motion for judgment. And that is what was done here.
It's a two-step process. You
It's a
get
two-step
default,
process.
and then you got to move for a motion for
Correct.
judgment because you have to deal with the problem of whether there are damages.
Correct.
Right?
And again, as noted, the entity itself, though unrepresented, was given notice of both steps.
Well, the notice only matters if, in fact, there's a power to enter a default for not having counsel. It seems rather extraordinary that you wouldn't be able to do it.
I again would return, there's nothing in 55A that says it's only a failure for an initial appearance. It says to plead or defend. Right now, this case was not being defended. It was not being defended.
Implies defend, which is a term that's been defined in Curley Customs and in the federal context from which our Rule 55A was drawn, has also been defined as not filing a motion that would defer the obligation to plead.
I am looking at the reporter's notes, which says that the prior law, GL 231, Section 57, authorized the clerk to enter a default for failure of a defendant to appear and answer.
Okay.
Now,
so there was no failure to, so maybe in the case of a failure to appear and answer, but there was no failure to answer here. Answer meaning file an answer, not answer present.
I can't understand how any process would work unless 55A applied to both.
Okay, so it could apply if, I mean, the entry of a default allows the plaintiff to skip over the liability phase and, in essence, get a damages judgment. If it's a ministerial amount, it can be entered by the clerk. If there's facts that have to be resolved, then there needs to be a hearing on damages.
That is correct.
But where a party had counsel, defendant had counsel, counsel withdraws, no replacement counsel appears. Does that dispense with the plaintiff's need to show liability? I mean, maybe the plaintiff can move for summary judgment at that point and no opposition is filed because there's no lawyer to file it on behalf of the corporation. Maybe the plaintiff has to go to trial, but I don't see what relieves the plaintiff of the obligation to prove liability.
I believe for the very same reason that if there's no first appearance and actual defense, now there's not going to be a defense to this case because there's no counsel who can defend, which is why also I think the idea of meritorious defenses plays such an important part in this balancing of should it be removed. Because right now, based on the concessions of LMH, both in its oral statements to the court, even in its brief to this court, it says we couldn't give an affidavit about any meritorious defenses because we can't find anybody who could testify to that. So what factual resolution could there be? Would it be an unopposed motion for summary judgment? That seems more work for the court.
Well, it might be more work, but, and maybe there is a gap in the rules that needs to be plugged. But given the rule as it stands,
Yep.
is this an appropriate situation for a default?
I would absolutely argue it is, Your Honor, and it's the most common sense reading of the Commonwealth's laws with respect to judgment, having that two-tiered
Is it the case, I'm sure you've looked, that there are no case, I mean, we have the case that your opponent has cited to us, which does have a similar sort of set of facts, which is unpublished, right? The decision from this court. Is it the case there are no other cases where counsel disappears for a corporation in the middle of the case, and
not
don't
where
have such a case? Wright and Miller haven't told us
not
what the
where the
federal rules say?
defendant, right, where the defendant then said that okay, now we're all in a freeze frame, that there is no way to proceed.
No, the defendant can move for summary judgment, or say, not the defendant, the plaintiff, your client, can say, let's go to trial, or I've got a summary judgment motion here, and look, I served it 2 weeks ago, we have no opposition from counsel, as is required for a corporation, so, at least enter summary judgment on liability, and then we can have a hearing on damages if we need one. Isn't that the proper way to proceed?
I don't believe that's the proper way, Judge. I'm going to continue to say I believe that reading 55A to allow for any failure of appearance, if it's a corporate defendant, to allow then to go to the second step, which is the judgment.
The hypothetical that Judge Sachs has just asked posits a filing of a motion that one knows will not be responded to, cannot be responded to as a matter of law. So,
unless the party gets counsel, which the LMH Heavy did. Sorry, LM Heavy.
Right, and which is what happened in this case as well, is that once the default was granted and the motion for judgment on that default, then counsel appeared, and it became an entirely different. But I just want to, before my time is up, reach back to the first question you asked, Justice Englander, which is with respect to preservation. At no point was the trial court given the opportunity to talk about this precise issue that we have just been spending the last 20, 30 minutes talking about. So for it not to be preserved properly, give the trial court a chance to weigh whether, in fact, the procedure was correct before appealing it to this court isn't the best way. The last thing I just wanted to add is counsel did refer to the fact that there were detailed factual allegations
what he did say, can we just go back? I understand your point, and it has a lot of power, at least for me. But what the motion, the renewed motion did say is 55A is the wrong vehicle. You shouldn't have done this by request. And there was an opportunity for you to file a motion at that point.
There's a slight gloss there, Your Honor, which is he didn't say 55A was the incorrect vehicle or a request because it doesn't apply. What he says is it was incorrect because we didn't comply with Rule 9. And remember, both 9A and 9C, neither would have been available. No one to confer with, and no one to do that other step of creating the 9A package that would have, I mean, there would be no package. It would just be us again asking for a default. Just the last point I wanted to make is with respect to the nature of the submissions by the defendant in this case. Yes, there were very detailed factual allegations. Yes, as counsel said, numerous documents accompanied the motion to remove. None of those documents were authenticated in any respect. There was no affidavit from anyone attesting to...
Anything that told you what to do with the documents? I had a hard time.
Some weren't even...
There's a bunch of documents. Was it up to the court to try to match the documents to the allegations in the complaint? Is that the idea?
Absolutely, and some were not even in English. And certainly there was no context for the court to say that there is a basis based on these allegations and documents for me to find a meritorious defense in this action.
If I understand where that argument fits in, it's even if the default was even if 55A was a proper vehicle to enter a default, or assuming it was, there's no abuse of discretion in not removing the default because there was a failure to show meritorious claims or defenses.
Absolutely correct, Judge Sachs.
And that's one of the, are the Berube factors even applicable here? I thought that was about removal of a default judgment.
We moved to more recent cases than Berube. We cited to the New England All Bank case, which went through the different factors. But obviously, the existence of having a meritorious defense is central to the idea. Why put the case back on the railroad tracks?
It's only central if, in fact, the default was properly granted. Because if the default wasn't properly granted, then you needed to go through a summary judgment process. It's only central if the default was proper.
Then this court would have to hold that it's only the failure to file an initial appearance that would allow a default followed by a default judgment. There's no case that says that. It's a pretty big step. All right, if there's no other questions, I'll rest on my brief. Thank you.
Thank you. Thank you to both counsel. And our final case of the day is number 23P386, Jane Doe, number 300581 versus Sex Offender Registry Board.
Started?
Yes, Mr. Hahn, please.
Good afternoon, Your Honors. Alex Hahn for Jane Doe. This is a significant and I think somewhat concerning case, and it kind of raises basic questions about these prosaic sort of civil procedure things that we've heard about in the last case. Do the principles...
I don't know if they were that prosaic. I think Rule 55's been around for a long time. It's amazing to me nobody knows the answer. Anyway.
Well, I have had a lot of Superior Court experience, and I was actually a law clerk with the Superior Court 27 years ago. So the thing that
You're going to tell us something about Rule 55, stop.
No.
That argument's over.
No, I am going to tell you about Rule 56, and that's the rule that was tattooed on us as law clerks.
What was the genuine issue of material fact here? I understand that Dr. Peretti's affidavit says the regs haven't been scientifically validated.
Correct.
Is that right? Does she go further than that to say the regs are scientifically invalid?
Well, she goes into a great deal of granular detail. I wouldn't say she's making these sweeping assertions, but...
Okay. But isn't that the burden of the party, of the challenging party? I mean, a properly promulgated regulation is entitled to a presumption of validity. So if there's no evidence either way that it's valid or invalid, then the presumption survives that it's valid. And it's up to the plaintiff to get to trial, at least, to establish an issue of fact that it's invalid, not merely that it hasn't been validated.
I think that may conflate the facial challenge, Your Honor, versus the as-applied standard. I might agree with you if this was a facial challenge saying we're going to sort of rip this regulation from...
There is no facial challenge here.
That's frankly what I'm saying, Justice Englander.
That's the way I read your complaint, and you concede no facial challenge is being made.
That's exactly what I was saying.
So I want to stop you then and ask the question that Judge Sachs just asked slightly differently. Is there anything in the Peretti affidavit that goes to an as-applied challenge?
Oh, absolutely, because... Excuse me?
What in the affidavit helps you with an as-applied challenge? She doesn't apply at all the facts of your particular client, right? She doesn't address the facts of your particular client in any way.
Well, my client is a female. She's in a class of individuals...
Get you that, okay. Beyond the fact that she's a female, how does the Peretti affidavit help you with an as-applied challenge?
Well, because it's establishing and opining with granularity based on contemporary studies that the existing assessment tools, such as the Static 99, are insufficient as applied to females.
But this is not, the board doesn't use Static 99. The board uses a 37 or however many classification factor system that has space at the end for the the offender to submit and the hearing examiner to consider any other useful materials, such as studies that were in fact considered here. And also, at the beginning says these apply to female offenders, but with a generally lower rate of recidivism. So the fact that she may be attacking assessment tools like Static 99R or I can't remember what the other one is, doesn't really go to the board's scheme, it seems to me.
Well,
there are lots of procedures adopted, in part in response to criticism from the SJC, that are supposed to guarantee the offender an individualized assessment.
Yeah, absolutely. And I think, I don't mean to be evasive on these questions at all, but I did want to contextualize it, as I was saying at the beginning. This is Rule 56, summary judgment, questions of fact. We have dueling affidavits.
Right, but are they on a material issue?
But Your Honors, we
have
know.
We have to ask, yes, they're dueling, they disagree with each other, but is the issue on which they disagree with each other a material issue to the validity of the regulation as applied, or even on its face if you had a facial challenge?
I think that parses the affidavits, and the facts of it more significantly than would ordinarily be the case on summary judgment. And I greatly respect the court's granular knowledge of these regulations, but I'm circling back to kind of where I was at the beginning, that if this were a case involving product liability and we had experts disagreeing on something, would we be parsing things to this?
100%. 100% we'd be parsing it. We would be paying attention to whether or not the issue that the experts disagree on is one of material fact. And the fact that a Superior Court judge might not pay attention is not going to bother me. I'm absolutely going to look at it. The question is, how material is what Dr. Peretti is saying to the argument that you're making, which is a as-applied challenge, saying that it is invalid as arbitrary and capricious as applied to your client, right? That's the question. Now, and that's why I come back to the question, how does Dr. Peretti's affidavit help you in that regard?
Well, I take your point that it doesn't get into the facts of her case that significantly.
Perhaps it doesn't need to. As you point out, it at least says we're talking here about a female. But what else? What else? What am I going to take from this that's going to say, that gets him over the hump? Now I need to take more evidence to evaluate whether or not, as applied to your client, this is an arbitrary and capricious regulatory scheme.
Well, the whole SORB classification scheme is based on science. That's the fundamental part of it. So I think for her to say that, you have most of, if not all of these regulations, essentially all but 4, say that we treat males and females exactly the same. Factor X applies to females the same way. That she's saying...
Except that we already have a thumb on the scale, which is part of the regulations, which says we have to understand that if it's a female, there's going to be less likelihood of recidivism generally, right? So even when we look at all these factors, we're still got a thumb on the scale.
Your Honor, I wouldn't view that as, I would very respectfully disagree with that. It's scientifically based. I mean, female offenders have like a 1% rate compared to like a 15% rate for men.
I'm not sure what you're disagreeing with me. I understand that there's a difference, and the regulation says there's a difference.
Yeah, the term thumb on the scale sort of implies we're getting kind of some sort of unfair presumption built in for us.
No, not unfair at all, no.
Okay.
Just, it adjusts the way you look at it. If it's a female, her likelihood of recidivism is going to be less. Hey, hearing examiners and SORB, you need to know that.
And she is saying, with granularity and based on contemporary studies, 2020, that this science concerning females needs to be more baked into these regulations. And
what is it that Dr. Peretti would have testified to a trial that was different from what Dr. Winsman testified to that was before the hearing examiner? Women are less likely to recidivate.
She's saying that the assessment tools, there aren't these assessment tools that are being used by SORB to address females that could be used, that's something that would have been fleshed out at trial. And I think that
No, I don't think she says that. I don't see her saying, here's some different assessment tools that would apply better to females. I think what she does say is the assessment tools you're using have not been shown to apply to females.
Yeah, I think that's a fair enough interpretation. And either way, Dr. Rita is saying, no, absolutely the opposite. And to me, that creates the factual conflict.
But even if Dr. Weidman doesn't even file an affidavit saying the opposite, is it enough to invalidate the reg to say it hasn't been proven valid? Isn't the presumption that it's valid?
Respectfully, I think you're asking us to prove our case at summary judgment. All we need to do is create a question.
Offer evidence that, viewed in the light most favorable to you, suggests you could prove your case.
And I would just respectfully say, that if we look at this affidavit, it's very detailed, and we can look at the studies. And
talking about looking at the studies, so she, Dr. Peretti, cites to a study from 2019, Miller and Marshall, comparing solo and co-offending female sex offenders on variables of pathology, offense characteristics, and recidivism. But as I understand your argument, you want to talk about this as a declaratory judgment appeal. You don't want to talk about the facts of this crime, which involved a solo offending female offender with contact offenses against multiple victims. So what is it in Dr. Peretti's affidavit or materials that says what she would have testified to that's different from all of the psych reports that are already in the record?
Well, again, and those are so old because the history of this case, I mean, the initial classification was 2012, and that's absolutely no fault of my client. So what would happen at trial? I mean, there could be, an examination, Dr. Peretti could perhaps examine the client, but we don't have to decide all of that now.
Yeah, you do. You have to put in, sorry, go ahead.
So are you appealing on the 30A part of the judgment or only on the declaratory judgment part of it?
Yes, Your Honor, the latter, Justice Grant. We are not appealing the 30A.
So you put a lot of reliance on this Doe 10800 case where the SJC talked about the difference between a declaratory judgment and a 30A.
Yes.
But where the issues are inextricably intertwined, where in the course of the 30A administrative process, the hearing examiner considered issues about female sex offenders and recidivism and the fact that there's substance abuse involved here and that your client had subsequent crimes, including false report of a rape. And don't we have to consider all of the 30A information in the course of thinking about the declaratory judgment appeal?
This is, I think, the fundamental problem with Justice Cowan's analysis, and I'd like to address this. Let's just play a little bit of a thought experiment. Let's say the two were separate. Let's say we have the whole 30A appeal, and that's adjudicated by Judge Locke, and then we have this complaint filed. Parenthetically, I think we all saw that the SORB answer conceded questions of fact. Do we all agree that that's in their answer? It says conceded questions of fact.
It doesn't concede that they're material. Or that they'll survive by the time it comes to adjudicating the declaratory judgment act.
Fair enough, but I think...
Continue with the experiment.
I think it becomes pretty close. But let's continue with the experiment. So we then have things occur as they did, but it's a separate case. Declaratory judgment. And counsel for SORB essentially makes Justice Grant's argument and says, as did Justice Cowan, this case has been decided by Judge Locke. What would be the vehicle for that? Res judicata. right? It would.
Federal estoppel.
Yeah, I mean, I just did a case on this, and everyone's calling it res judicata. So
Let's talk issue preclusion and claim preclusion. That way there'll be no ambiguity.
okay, and I can give you a citation that they're now viewed as pretty similar, kind of an omnibus res judicata. But anyway.
I hope that's not true.
But anyway.
I'm quite certain that's not true, counsel.
Okay, but
They're two extremely different concepts that are addressed differently in all the case law that I'm familiar with. Collateral estoppel, same issue. Let's talk about that.
all right. So the core principle of that is this. You are barred from relitigating a claim that you either brought or could have brought.
That's res judicata.
Brought or could have brought. That's the standard. And in this case, absolutely you could not have brought it. It's two different standards of proof. It's entirely different. In a declaratory judgment,
I'm not really sure where the experiment is getting us, because couldn't Judge Cowan, even if Judge Locke had never decided the 30A, even if it was just pending and hadn't yet been decided, couldn't Judge Cowan have given exactly the analysis she did, which is look at how the regs were actually applied to your client here. There's nothing arbitrary and capricious about it. The lower recidivism rate was acknowledged by the hearing examiner. The particular facts of the additional materials, the studies that were offered, were cited and discussed and, in essence, applied by the hearing examiner. Say, yeah, there are some factors that do apply particularly to women, such as whether it's a solo offense or a co-offense, and that indicates that the plaintiff does have a high risk here. So even if the 30A had never been brought, isn't everything that Judge Cowan said in her decision, striking through the references to Justice Locke, but adopting all that analysis as her own, why isn't that enough to resolve the as-applied challenge?
well, I think respectfully we're reviewing Judge Cowan. I think you just wrote a much better summary judgment opinion.
Well, she said, well, we can affirm on any ground. So.
You can affirm on any ground, and the last thing I would say, Your Honor, I know I'm out of time, why not remand for a little bit of expert discovery? What's the harm? These are important issues. Let's just have at it. Let's have these experts put on the stand. And we already had Judge Canone say expert funds. Why don't we defer to her and just let's mix it up a little bit and learn a little bit more about these issues, and maybe we have better regulations.
Sounds like you're
they
making
can
an
move for summary
argument
judgment
an
again.
advisory opinion.
Sorry?
Sounds like you're making an argument for an advisory opinion. It sounds like the kind of thing that regulatory bodies do when they sit down and take evidence from whatever source they feel like they should take evidence from, rather than what courts do when they try to adjudicate the rights of a particular party.
I'm happy to
Just answering your question.
I'll put the meat on, whatever meat on the bones at trial. If you just give me a couple of depositions, that's all I'm really asking for here. Thank you very much, Your Honors.
Thank you. We'll hear from the board.
If it pleases the court, David Chennai for the board. The board's position is that from the very beginning, this was an as-applied appeal. And I think that looking at both judges' decisions, they treated it as an applied attack on, not so much an attack on the regulations, but that it comes down to, in the end, how it was applied to her. And I think when you look at how it was applied to her, the board's regulations worked the way they were supposed to, starting with the fact that the hearing examiner found that that she begins with a low base rate because she's a female offender. Then looked at the studies that the plaintiff brought in and looked at them and said, wait a minute, a lot of these characteristics, dynamic risk factors, she has those factors that could increase according to the Cortoni study, and then factored that in as well to reach the level 2. Now, that's what basically Judge Locke was saying. When you're attacking the regulation as a challenge, as an applied challenge, well, it was applied properly to her. The board's regulations worked. And when you get to the level of Judge Cowan, she looks at the affidavit of Dr. Presiding and says, that affidavit doesn't change the fact that that it worked in this case
Worked in this case.
for this individual.
Well, you have Peretti saying many, I think is the right answer, many of the factors that you guys are supposed to look at do not apply to females. She says that, right?
She does say that.
And many of those factors were applied by the hearing examiner.
Correct.
So is there an issue of fact with reliance by the, in this case, reliance by SORB on factors that Peretti says, that's error. The materials, the current science says those factors don't apply.
But the problem with her analysis is that when she makes that, for instance, one of the issues is the criminal law, a person with a criminal background. She cites a study and then ignores it. The study she cites specifically says that when you do the static...
You're arguing facts.
Correct. I'm actually arguing her credibility on these issues.
If you're arguing her credibility, that means summary judgment was inappropriate. The case needs to go to trial.
No, I'm saying that it was appropriate because it was an applied challenge. It wasn't an attack on the actual constitutionality of the regulations. It wasn't a facial challenge. It was as applied. And I think both judges...
As applied. I'm looking, here's the argument. Looking at how you applied it to his client, to your opponent's client, you, SORB, relied on this factor, this factor, this factor.
Correct.
Peretti says, this is what he says. Query whether this is exactly what Peretti says. Peretti says this factor, as a matter of science, does not apply to females.
No, she didn't say specific factors. What she said was the factors in general. The board's factors in general. I don't remember her saying that there was a specific factor that didn't apply. And again, when you look at the different factors, when she says that, for instance, she says the board's factors don't apply to male offenders. She also says there is no analysis, no risk dynamic factors established that show that would indicate female recidivism, which actually is not true because Cortoni says there are some, and the study she cites says actually there's a convergence. People with criminal histories, actually men and female, has the same impact, which until 2018, that issue had never been raised. So now you've got a new study that says, oh, wait a minute, criminal activity by a female offender does increase risk. And that's one she cited. That's now a dynamic risk factor if you accept that study, which shows that, which everybody says, including Dr. Purdy, this is an evolving area. There's very little research on female recidivism, mainly because it's such a low risk, they have such low recidivism rates. In fact, the study that Dr. Peretti cites specifically says we need to get at least a cohort of 100 recidivistic females, which we haven't reached yet, to do that. So they can't even come up with a study that would be definitive on these issues. But what's interesting is she says the only way, and she ends her affidavit with this, the only way you can tell if a female is going to be sexually recidivate is if there's some specific indication, then she puts in parentheses, like she tells you she's going to do it again, and puts that in parentheses. Now, first of all, Cortoni says there are risk dynamic factors, at least, and this is from 2007, there's at least 5 that he cites, which she actually has most of those. And then this new one, it says, wait a minute, we also find, looking at static 99 scores between females and males, there is a convergence with criminal activity, which again, it's part of the evolving process. Now, why the board's regulations work is because now an individual can bring in that study and show we have this dynamic factor. Or they could just not bring the study in and show so that the board would have that information. But again, the reason why it works is because new studies can be brought into evidence, and it has to be considered by the hearing examiner, and that's DOE 20561, DOE 151564.
If there were scientifically conclusive evidence that a particular factor doesn't apply to females, it shouldn't be applied, right?
If you can say there's a specific factor and you have the evidence, now a good example is DOE 22188 with factor 2. It was proven that the first part of factor 2 is not based on scientific studies of any kind.
And compulsive?
Excuse me?
Factor 2 is repetitive and compulsive
Right.
behavior?
And again, so it was declared because there was no research backing that the board could no longer use that portion of the factor. And it's the same here. If you actually have a study come in and say, wait a minute, this factor specifically does not apply to female sex offenders, then the board has to consider that. Now, what would have to happen is then it would have to go to court and have a judge declare that the board's use of that regulation is no longer valid. Or the board could do it on their own based on the research. But again, that's the evolving nature of the regulations, the evolving nature of
So if
the
Peretti's
process.
affidavit said, based on this conclusive scientific study, factor 10, which has to do with, is that the alcohol?
That's the
one?
criminal. Factor 9 is the alcohol.
Say says factors.
I know the
9,
factors too well.
One of those is predictive of recidivism in females, based on these studies. That case goes to trial. Yes?
Yes, if she said there was a specific factor that didn't apply, not a general, what she's saying right now is that there's no evidence to prove that the board's regulations, because she says there's really no no evidence whatsoever through the studies. What she's saying is that there's no evidence that proves that the board's regulations either work or don't work, is essentially what she's saying. She's not saying that the board's regulations are improper. What she's saying is that because they're not gender neutral or gender specific, they shouldn't be applied to females. But she's not listing any proof, any studies that show that the board's analysis is actually improper as applied to females. She's making a general statement that her reading of the factors says that the board's regulations shouldn't be applied to female offenders.
So if there's an expert affidavit that says there's absolutely no scientific evidence to support the validity of a particular factor, and that fact is uncontested, the board can't find any expert to say, oh no, look at this study, it supports the factor. Then in that instance, where it's uncontested, there's no scientific evidence to support the factor, is that enough to show that it's invalid, or can the board nevertheless come back and say, well, but according to a common sense approach, this factor should have some bearing on the recidivism or the seriousness of the harm that would result? Is that enough to keep the regulation in force?
No.
Unless that common sense approach is also proven to be
No.
invalid or irrational.
No, because I think there's I think it's back in 2006, it's one of the triumvirate of cases. I think it might have been 3844 or 10216. One of them said specifically the board does not have to base a regulation on a scientific study. So that's not enough. I think what you have to have is evidence that it's completely invalid, not that it's not based on research. It's got to be shown that it's specifically invalid, like 22188, it was shown to Justice Wilkins, and he accepted the proposition that the first half of Factor 2 was not constitutionally valid. Because in that case, it's because it wasn't based on...
As opposed to not supported scientifically, it was incorrect.
Correct. That's the difference here. It was incorrect. And again, the board's, regulations are trying to further the legislature's intent. And the burden is on a plaintiff, even at this level, if he's going to make a facial challenge against it, he has to show that the board's regulation, as a specific regulation or all of the regulations, that they do not, they don't relate to the legislature's intent reasonably, in this case, to protect the public from dangerous sex offenders, as the statute says, the enabling statute says. So I think in the end, the matter comes down to the fact that Justice Cowan had the authority to look at Dr. Peretti's affidavit and determined correctly that it did not state that the board's regulations were unconstitutional unconstitutional as applied to this individual. And I think that's the bottom line.
Can you clarify at least your understanding, and I should have asked plaintiff's counsel, plaintiff's counsel, right. Is the challenge a constitutional challenge or a challenge that the reg is inconsistent with the statute?
I think it's probably more inconsistent with the enabling statute, because you've got to prove that it doesn't bear a reasonable relationship to that as part of an attack on a regulation, or at least a constitutional attack. But again, you can't get away from the fact that throughout this, the complaint in this matter, the declaratory judgment complaint, was as applied. It wasn't a facial challenge against the regulation itself. And Dr. Peretti never addressed how it was unconstitutional as applied to this individual.
I'm curious about the notion of a declaratory judgment action challenging a regulation as applied. Is that really an appropriate subject even for a declaratory judgment action, which is supposed to be to the validity of or an interpretation of a law, a regulation, or a constitutional provision, or whatever it might be, but isn't designed to determine the validity of an individual adjudication?
I think the declaratory judgment really should be focused on the constitutionality of either a regulation or the regulations in general, not as an applied to. I mean, and that's where, when you mix declaratory judgments with 30As, and the issues are so intertwined, as Justice Grant said, that's where you get the confusion in the decision-making, because the judge in this case said, the regulations were proper as they applied to this individual. Judge Locke said that. Judge Cowan accepted that finding. And that's what happens when you combine the two processes.
I thought that the case law in this Commonwealth, going back many, many years, said that if you want to challenge the validity of a regulation, you want to say that it's invalid, you don't do that through a 30A. Someone could quite reasonably question whether that makes good sense, but I thought we had case law that says that.
What we have is, and this is what started the whole confusion, back in, I think it's 2012, Doe 10800, which I argued, and Justice Spina specifically said there are two separate avenues, two separate vehicles, and he's advocating that they not be combined. But what's happened is, procedurally, it's been combined quite a bit. I mean, I'm constantly getting
I think it's because there was this concept that the administrative body didn't have the ability to declare the regulation invalid.
Right.
Either statutorily or constitutionally.
Right.
That was the concept, right?
And since Doe 10800, the SJC has said there may be circumstances where the issues are inextricably intertwined. I didn't come up with that myself.
Right.
A couple of questions for you about the record. The only two studies that we have in the record, as I understand it, are the 2005 and 2007 ones that Judge Link cited.
Right, because they were submitted
By Mr.
at
Tennant
the
at the
classification hearing.
Yes. So we don't have any of these ones with the nice titles that sound very interesting.
No.
From 2020 and 2021. I'm interested in this idea about whether or not the regs are gender neutral versus gender informed. And I'm wondering, this is more a philosophical question, how that would work in situations where the SDP is transgender. And I say this in part because I spent a lot of time looking at Judge Lank's case, where she starts off by saying John Doe, comma, a female, and I couldn't figure out why it was John Doe, a female.
Right.
And there's some other transgender cases. So I thought we were getting away from this idea of sexuality as a binary thing. And now, anyway.
Well, I think, I think your point's well taken. I've had, in the last couple of years, a handful of transgender cases, but the problem right now for that, there is absolutely, to my knowledge, no studies regarding transgender and transgender recidivism. And that's one of the issues. And I'm sure they're going to start having studies because you're seeing more and more of it. And then we'll have a better idea.
Depending on which way they trans, too.
Was the Lank case, John Doe, a female? Is that a biological female since birth? Do you happen to know? Is that just
I don't know off the top of my head because I didn't handle that case.
Yeah.
And again, that was in the very beginning of the whole transgender becoming an issue in these cases.
Right.
And it's going to be an interesting issue because it also goes down to if they're transgender and have started the process for becoming a female, does that change their hormonal or testosterone, or whatever hormonal situation would change? And I think I had one recently where they brought in an expert on that, and the expert basically said, we don't really know yet because there's really no studies on this issue.
All right, something to talk about in the next case.
Thank you.
Thank you both. We are adjourned. I want to thank our court officers and our law clerks and, of course, our clerk's office staff for assisting.